One bail application number 7149 has not been displayed till date. 74 सब लड़ता हुआ है
आप डिफेक्ट कब रिमूव किए?
23 जुलाई
इसका पता करिए कि
जैसे
फाइल से के नाम
लिख दें
या इसका फाइल मंगाइए और पता करिए केस लिस्ट क्यों
लिख दिया
आप आ जाइएगा सेकंड हाफ में तभी लिस्ट होगा कम नहीं
From supplementary list for case filing item 1, DA 7115 of 2026.
Hello, cyber letter madam. No victim madam. One mobile phone hello madam. And classes submitted.
one moment use name
Mobile belong to the person. Mother's one lady
no victim
no, but screenshots ready mobile number and
एक सेकंड उनका बात पूरा सुनने लीजिए चार्जशीट हो गई देख देख
हेलो रे सप्लीमेंट्री फाइल देख लीजिए 3/8/2000
कस्टडी कब से
हेलो
कस्टडी
मालूम पारा 15 मालूम 13/5
13/5 नो एंटीसीडेंट विक्टिम कौन
स्क्रीनशॉट में कुछ लोग से महानगर गैस लिमिटेड का जो कस्टमर है उनका मोबाइल नंबर ईपी नंबर आईडी ये सब और सप्लीमेंट्री
or the learned counsel appealing on behalf of the parties. The counsel for the petition submits that the petitioner having no criminal antecedent is in custody since 13/5/26. Charge has been submitted on 3/8/26. No victim has been identified. One mobile has been recovered from the possession of the petitioner, which is in the name of the petitioner.
बोले हैं उसके दादाजी बोले कि वो उसी से name of Jayanti
which is in the name of the petitioner. The learned counsel for the state has opposed the prayer and submitted that the SIM found on the mobile was in the name of another person, one unknown person, namely Jayanti Devi, which was used in the commission of the cyber crimes. However, he does not dispute the other submissions made by the counsel for the petition. Considering the fact that the petitioner has no criminal antecedent and charge sheet has already been submitted, the petition is directed to be enlarged.
Item 2, BA 7272 of 2026.
Argue your case.
No, my ground and the other two person was having same and similar allegation has been granted me. And confession led to commitment has come on the confession statement of Sir Dev Munda. I am Dhan Singh. And this time belongs to other two person has been granted by me.
क्या बोलना?
तो बोला मतलब कि confession of the husband of the deceased member to disclose that he has given the supply of 2 lakh rupees.
Husband का तो bail हो गया.
Husband का भी दे
हो गया.
husband का बताओ. और तो इनका है कि ये कॉम्प्लिसिटी है इनका मर्डर में और इसमें चार्ज हुए हैं इसमें
चार्ज पेमेंट कब हुआ? इसमें जो चार्ज हुए हैं 6 में 6 7 okay cases at prosecution heard the learned counsel is appearing on behalf of the parties. The learned counsel for the petition submits that the petition is in custody since
19/3/2016.
19/3/2026. Charge has already been framed for alleged offence, framed on 6/7/2026 for alleged offence under section 103(1/3)(5), 61(2) of BNS. It submits that the name of the petitioner has come in the confession statement of accused, and there is no recovery on the basis of the confession statement of this petitioner. Recovery has been made on the basis of confession statement of accused, namely
Sadhdev Munda.
Sadev Munda. Are you named in the FIR? Are you named in the FIR?
No.
The petitioner is not named in the FIR. The learned counsel for the state has opposed the prayer for bail and has submitted that the husband of the deceased had hired the petitioner and others to commit the murder of his wife. Yeah. To this, the counsel for the petitioner submits that the husband has been enlarged on bail in BA number 5644 of 2026. Dinesh Melgandi naam hai na Gandhi. After hearing the learned counsel for the parties and considering the aforesaid submission that the name of the petitioner has transpired in the confession statement of accused and no material as such has been pointed out by the learned counsel for the state to link the petitioner with the alleged offence. And similarly situated accused have been enlarged on bail. The petitioner is directed to be enlarged on bail. कोई antecedent है?
No.
उसमें ऊपर लिखे the petitioner has no criminal antecedent. कोई counterfile हुआ है?
Name.
The state, the learned court shall call for a report from the state with respect to the criminal antecedent of the petitioner. And if the petitioner has any criminal antecedent, the petitioner shall not be released. इसका एक का खाली बेल बाकी है, बाकी सबका हो गया.
जी.
जिसके कन्फेशन पे रिकवरी,
Yes.
वो उससे नहीं मूव किया ना,
इस पर
उसने मूव नहीं किया.
नहीं.
वो फिर बोले कि हम 2 लाख रुपया दिए हैं मदद करने के लिए हुए.
हाँ, लेकिन 2000 रुपए दिया.
हाँ, it is a disclosure.
कोई मनी ट्रेल नहीं है, कुछ नहीं है. और बोला है कि 2000 रुपए दिए, मतलब टिल द कमीशन ऑफ ऑफेंस 2000 रुपए दिए.
Item
ये
3.
केस डायरी जो है ना उसी में रख, जहाँ से आया था.
Item 3 BA 7285 of 2026.
Also,
Item 4 BA 3782 of 2026.
also for the petition seeks permission to withdraw this bail application. Counsel for the state has no objection to the prayer for withdrawal. Accordingly, this bail application is dismissed.
Santal. Item 5 BA 6547 of 2026.
Initially, a fire was registered under section 69(3)(5) of the
Custody कब से है?
First time in custody since 11/4/2026.
एक second. 11/4/2026.
26.
Charge sheet submitted.
Charge sheet
Under
charge
which-
is also
Charge paid under which section?
69.
69. Only 69.
Only 69.
When was the charge paid?
Charge was paid on 18/3/2026.
18.
Sorry, 16/3/2026.
आप कस्टडी बोल रहे हैं 11/4/26 से, चार्ज बोलते हैं 18/3 को.
June 6.
18/6.
16/6.
26. 16/6/26, so charge was paid. So what is the allegation against you?
Lordship, may I kindly see page number also.
We'll see the statement of the victim straight away. Where is the state?
Earlier also notice was also issued to the victim also. They have appeared by filing order.
Yes, you are for the informant. What do you have to say? You have seen your statement under section 183.
Yesterday I filed my lord.
No, ऐसा ये सब कहानी नहीं चलेगा. 183 का statement है. You yourself is saying that she was having relationship with the petitioner for last 1 year, for last 4 years.
And now both have compromised.
शादी हो गई?
नहीं अभी तो मुझे
Victim compensation मिला? Or the learned counsel is pleading on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since
11/4/26.
11/4/26. Charge has been framed under section 69 of BNS on 16/6/2026.
18/6.
Sorry, on 18/6/2026.
Sorry, Lord. 16/6. Sorry.
On 16/6/2026. He submits that as per the case of the informant who happens to be the victim, she was having a relationship with the petitioner earlier and then he refused to marry. The case was quashed. The statement of the victim recorded under section 183 BNSS has been placed on record, which reveals that the victim has stated that the victim has stated that she was having relationship with the petitioner and when he refused to marry, she ultimately lost the case. The learned counsel for the informant on instruction has submitted that he has no objection to the prayer for bail of the petitioner, correct? After hearing the learned counsel for the party and considering the statement of the victim recorded under section 183 BNSS and charge sheet having been submitted and charge having been framed, this court is not inclined. This question is directed to be enlarged on.
From tail list for orders item 1, DA file number 18196 of 2026.
Present petition has been placed for check
There is a direct allegation against you.
direct allegation against me, but the application of it, which I have been performed, the office is making an objection with regard to its maintainability.
Yeah,
My lord,
this is for orders.
my lord.
उनको जरा बुलाइए मिस्टर पंकज कुमार। ये तो मेंटेनेबल है। There is an order of coordinate bench.
My lord, the date on which incident took place. Petitioner were met. Having the age of 16 years, 11 months and 9.
That's right. He has been declared
Yeah.
as major as adult.
Adult. And
Yes.
the cases and by right order your lordship by the competent court directing the concerned my lord to the cases of the petitioner be tried as an adult
As an adult before children's court.
before children.
Why this bail will not be maintainable?
We will like.
Appeal will lie even under such circumstances.
101 within the bracket
If the order is of the
Children's
children court, appeal will lie before this one, single judge. Handed appeal will lie. If the order is, the main order is of the juvenile justice board, then appeal will lie before the children court,
That's
that
right.
is session judge. And the revision lies before this one. If the original order is from the children court, appeal will lie.
My lord, let the office be directed to convert this bill application into a plea.
No, you will have to seek fresh wakalatnama also. We'll return you the certificate. Wakalatnama fresh लगेगा ऐसे नहीं convert. Bill number 18196 of 2026. An office objection has been raised that the present bail application is not maintainable as the interim order has been passed by children's court. And earlier an order was passed that the petitioner is to be tried as an adult. The learned counsel for the petitioner submits that he may be permitted to convert this bail application into appeal, criminal appeal. After hearing the learned counsel for the petitioner, this bail application is held to be not maintainable and it will be open to the petitioner to file criminal appeal against the imprisonment. Revisable है कि appeal ही lie करता है?
Appeal.
Office is directed to return the certified copy of the interim order to the learned counsel for the petitioner upon being replaced by photocopy of the same certified to be true copy of original by the counsel. A fresh file. This question.
Progress filing item 2, DA.12.08.2026.
Basically, the first information report. The husband, he has lodged his first information report. He on the LS date, that is on 30th of May 2026 while he was in Patna. Subsequently, after his wife, after taking a dinner, was in home, and it has realized that 3 named persons, including this very petitioner, they have entered into the house and they have assaulted the wife of the informant by stone and by iron rod. Thereafter, due to severe sustained injury, and thereafter 8 days, the first information report will be lost. You will receive the first information report, which is at page 18. So far, the allegation, there is no specific act or what act against this petition that by which means by which weapon he was using and by which he has assaulted the in a general and omnibus allegation. This very first information
First information report has been lost by the husband.
has been allowed.
So he lost an information on the information given by his wife.
Wife.
Wife has made an allegation. She suffered very serious injuries.
So far, the injuries
Or
sustained.
previous injuries. she
Yes,
has suffered.
one injury has been sustained and 3 persons have been made an active. And so far, again, this petition, again, there is no specific allegation or specific overt act he was assaulted by means of threat or by he was in his hand.
Stage क्या है किस? Stage. आपको पता ही नहीं 8/6/26 से कस्टडी में or the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 8/6/2026 and he is not aware as to whether the charge sheet has been submitted or not. The learned counsel submits that in the FIR there is general and omnibus allegation against 3 accused persons and there is no specific overt act as against the petitioner. The counsel for the state has opposed the prayer for bail. After hearing the learned counsel for the parties, it appears from the records of this case that the FIR was lodged on the information received by the victim by her husband. And the victim has, the impugned order also reveals that the victim has disclosed the name of the petitioner or of the accused persons, as a result of which, and due to assault by them, she suffered grievous injury on her head. In view of the aforesaid facts and circumstances, and the fact that the victim suffered grievous injury, this court is not inclined to enlarge the petition on bail. Hence rejected. The petitioner may renew his prayer for bail after 9 months. But the victim examined it.
Item 3, DA.12.08.2026.
Victim is 15 years. She has said that she asked to go to motorcycle thereafter. So only one thing that to be pointed out during the course of investigation, she has expressed her desire to marry the petitioner. That has come in her 180 statement report.
That is of no consequence.
That is the thing, otherwise, medical also.
She is in custody since 22/5/26.
Yes,
Charge sheet has been submitted.
Yes, charge sheet has been submitted on 10/6/2026. She is in custody since 22/5.
Heard
And there's a delay of 6 weeks.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that there is a delay of 6 days in lodging the FIR, and it is alleged by the victim, who is also the informant of the case, that the petitioner committed rape upon her under fear of life. The learned counsel submits that though the victim is minor, aged 15 years, but she wants to marry the petitioner. The learned counsel for the state has opposed the prayer for bail. After hearing the learned counsel for the parties and considering the direct allegation made against the petitioner, and the victim being 15 years of age, and the impugned order reveals that she has supported the prosecution case in a statement recorded under section 183 premises. This court is not inclined to enlarge the petition on bail. ऊपर लिखा charge sheet has been submitted on 10/6/26. अभी तक तो victim को examine हो जाना चाहिए. Charge frame नहीं हुआ. See, let the victim be examined. Then, depending on her statement and her examination, as per the POCSO Act, within 1 month from framing of charge, she has to be examined. Right? So, एक बार हमने देखी, उसके बाद we'll see उसका क्या statement आता है.
There is an element of love affair from.
We'll see. Let us अभी तक तो 183 तक तो वो आपके अगेंस्ट में है. हो सकता है कि जब उसका एग्जामिनेशन हो, let us see what she says.
Item 4, BA 7303 of 2026.
My lord, permit the father of victim and छेड़खानी का केस है. A 183 का statement हुआ है, kindly report.
Custody कब से है?
Custody में है my lord, 15/6/26.
चार्जशीट हुआ? चार्जशीट
Instruction.
आपको बेसिक क्वेश्चन भी आपको पता नहीं होता. इन्वेस्टिगेशन स्टेज में बेल फाइल करते हैं, कोर्ट पहले ही पूछेगा आपका चार्जशीट हुआ कि नहीं हुआ. नहीं हुआ.
183 statement called for हुआ था last occasion.
नहीं, पहला.
FIR पढ़ी.
FIR में निवेदन पूर्वक कहना है कि मैं गिरिडीह का निवासी हूँ.
आप ही पर तो मेन एलिगेशन है.
तो कि 3 लड़का आया.
लेकिन सारा एलिगेशन आपके ऊपर.
3 लड़का आया.
शादी आप ही से करना उसको.
नहीं, ये 2 लड़का बोला. ये 2 लड़का बोला कि शादी इन्हीं से कर लो. फिर वो हल्ला कर देंगे कि सब लड़का लोग भाग. यही एलिगेशन है इसमें.
ईटा पत्थर से
Dust her private part, open her skirts, milord, while daily regularly school से आने में disturb.
मतलब स्कूल से आने जाने में तंग करके
The tower location of the 3 boys, milord, is at the place of occurrence, milord, on the alleged date and time.
Only
It has come.
only prayer 183 का statement. 183 का देख लीजिए. डायरी में सिर्फ इतना ही है कि
For the learned counsel appearing on behalf of the parties, the learned counsel for the petitioner submits that the petitioner is in custody since 15/6/2026. And though he is a named accused in the FIR, but he has been falsely implicated in this case. The learned counsel for the state and the informant has opposed a prayer for bail and have submitted that
statement recorded under section 183
the
supported.
statement and have submitted that charge sheet has not been submitted so far.
183
And
also supported.
the impugned order reveals that the victim, aged 15 years, has supported the allegation and in a statement recorded under section 183 BNSS. And as per the FIR, the petitioner and 2 others used to trouble the victim while she was going to her school for a long time. And they had also attempted to assault her physically.
Yes.
काफी इतना ही.
No, physical.
And when the
It's wrong.
when the informant objected to the conduct of the accused persons, the other accused persons named in the FIR assaulted the informant and violence. In view of the aforesaid facts and circumstances and direct allegation against the petitioner, this court is not inclined to enlarge the petition on bail hence rejected.
So let's say 2120 में लिखा हुआ है कि this case is pending at the stage of investigation.
हाँ, लेकिन पिटीशन के ऊपर
20 में
दो लड़का के ऊपर एलिगेशन है कि वो लोग बोला कि इस पर शादी करो, लेकिन
Yes,
डायरेक्ट
so the
लड़का
counsel for the petitioner has submitted that he is not aware as to whether the charge sheet has been submitted. देखिए एक फंडामेंटल चीज है, आप लोग डेट फाइल करिए, हम सुनेंगे, सब बात नहीं है। लेकिन इन्वेस्टिगेशन स्टेज में बहुत मुश्किल है।
जब क्लियर है
मतलब आप थोड़ा सोचिए, इन्वेस्टिगेशन स्टेज में आपका बेल मैटर यहाँ पे आ जाता है। अभी तो इन्वेस्टिगेशन चल रहा है, तो क्या हम कंसिडर करें? लिबर्टी तो आपके पास है अभी। देखिए, from the date of framing of charge under POCSO Act, the victim has to be examined within a period of 1 month. Victim examination कराइए और आ जाइए। We'll see. चार्जशीट नहीं, after examination of victim. Victim का security secure करना है, right? Victim examination हो जाए, उसके बाद आप आइए, तब हम देखेंगे क्या है। इससे पहले नहीं। स्कूल आना जाना मुश्किल करती है। As per the allegation. Only as per the allegation. अभी कहाँ, अभी conviction थोड़ी हुआ है कि हम आपको ऐसा कुछ बोल सकते।
Item 5, BS 7308 of 2026.
Rejected by the coordinate means manner. It's in case of 376. The victim is 33 years of age. The petitioner is 21 years.
तो 376 नहीं हो सकता।
Frame हो सकता है।
Charge frame हुआ 7725.
हाँ, 6 witnesses.
Out of 13, 6 witnesses have been examined. Till
उसके बाद एक भी नहीं हुआ। 12/2/2026 लास्ट 10/2/2026 को हुआ था।
12/2/26.
हाँ, उसके बाद फिर एक विटनेस एग्जामिन नहीं।
आपका ट्रायल एक्सपीडिएट कोई एफएसएल है?
हाँ, मैरिड प्रोसीडिंग से कंसेंशुअल
No,
if prosecutor तो FIR itself it is evident मानो कि जब मैं देवर
ये मेरिट पे था, आपका रिजेक्ट हो गया ना?
ये मेरिट पे हुआ लॉस, बट नॉट स्टेज has been at that time 25 को रिजेक्ट हुआ लॉस। Thereafter, my lord, the stage has changed. My lord, now witnesses are examined.
Witnesses are being examined. The victim has not yet been examined.
No, victim examined, my lord. And she supported the case of.
कहाँ है? कब?
I have my certified.
आप बोलते हैं उसके बाद कोई एग्जामिनेशन?
12/2/26 के बाद से उसके पहले PW
पूरा victim तो एकदम supportive।
My lord, supportive there also, but there's an element of love there.
No.
There seems.
नहीं, ऐसा है, आपका ट्रायल एक्सपीडिएट कराना
चाहिए।
4/25
से कस्टडी में लॉस।
आपका ट्रायल आप नहीं आए ना विटनेस, तो आप आ जाए। विटनेस आएंगे ना?
एक साल
Victim तो एग्जामिन हो गया।
मोर देन
Victim जो विटनेस है ऑलरेडी एग्जामिन।
6 महीना से
आगे वगैरह का एग्जामिनेशन बचा हुआ है।
तो इनको करवा देते हैं।
6 महीना से एक भी विटनेस
आप नेक्स्ट डेट बताइए ना, आपका विटनेस आएगा। आप डेट बताइए। हाँ बताइए, खाली डेट बताइए आप। नेक्स्ट डेट कौन सा?
नेक्स्ट डेट इज माय लॉर्ड 23/9/2026।
गवाह आना चाहिए, ठीक है।
एंड लास्ट विटनेस वाज एग्जामिन्ड ऑन 10/2/2026। एक महीना 2 महीना का टाइम डेट मिल रहा है। That is such difficulty, my lord, and I am remaining in custody for more than one year 3 months.
किसका एग्जामिनेशन बाकी है?
7 लोगों।
यस, काउंसिल किसका एग्जामिनेशन बाकी है?
My lord, victim examined. Thereafter, my lord, PW3, Sri Devi mother also examined. Narayan Jadhav father also examined, my lord. Manoj Tiwari PW1 also examined, and PW5 Narayan Mahato also examined. Only, my lord, IA and doctors.
IU and doctors are remaining to be examined.
No, 7 witnesses are remaining to be examined. This is only 6 witnesses. Total 13.
I have 5 positions, my lord.
I heard the learned counsel appearing on behalf of the parties. The learned counsel for the petition submits that earlier the bail application, the petition was rejected on merits. While order dated 25/8/2025 in BA number 7188 of 2025. And thereafter, the charge was framed on 7/7/2025. And out of 13 witnesses, only 6 witnesses have been examined so far. The last witness was examined on 12/2/26. 10/2/26. And the next date is 23/9/2026. The learned counsel for the informant, while opposing the prayer for bail, has submitted that primarily the official witnesses are remaining to be examined, and they have supported the prosecution case. यही बोलना चाहूँ. The learned counsel for the state has submitted that witnesses will be promptly produced before the court. And there is direct allegation. There is direct allegation against the petitioner. After hearing the learned counsel for the parties and considering the fact that the bail application was rejected earlier on merits, and out of 13 witnesses, 6 have already been examined. This court is not inclined to enlarge the petition on bail. However, the state is directed to ensure that the remaining witnesses are promptly produced before the court. The next date, as indicated by the counsel for the petitioner in the trial, is on 23/9/2026. The petitioner may renew his prayer for bail. However, considering the custody of the petitioner, he may renew his prayer for bail after 6 months. 6 महीना में आपका ट्रायल नहीं कंक्लूड हो हाँ वो तो डायरेक्शन है. The counsel for the state is directed to communicate this order to the SP of the concerned district and direct the prosecution to ensure that the remaining witnesses who are apparently official witnesses are promptly produced before the court. Default नहीं होना चाहिए आपका. 23/9 को डेट है 23/9 और चेक कर लीजिए, आप लोग का काम है चेक करना.
Item 6 BA 7310 of 1026.
थोड़ा इन केसेस में जिसमें विक्टिम एग्जामिन हो जा रहे हैं, आई थिंक थोड़ा सा शिफ्ट करने का जरूरत है. हर केस में रिजेक्ट नहीं कर सकते, डिपेंडिंग अपॉन द कस्टडी एंड there may not be likelihood of influencing the witnesses if they are examined. But you wait for some time. 6 months. 6 months आपके लिए ही नहीं, in general भी है ना. क्या मिस्टर पंकज, अगर मान लीजिए मटेरियल विटनेसेस हैव बीन एग्जामिन्ड, उसके बाद कोई इन्फ्लुएंस करने का कोई चांस नहीं है ऑफिशियल विटनेसेस, then under such circumstances the accused may be released on bail, isn't it? Inappropriate case.
Is inappropriate.
376 वगैरह बहुत सीरियस ऑफेंसेस है, लेकिन अदरवाइज
सीरियस ऑफेंसेस में इवन इफ द विक्टिम इज एक्जामिन्ड
तो भी उसको रिस्क रहता है थोड़ा.
Yes, serious allegation is attributed by the victim.
That's
And he says because it should be a deterrent effect to others also.
वो सब थोड़ा बैलेंसिंग है.
Yeah, it is just for balancing the will not be
That's right.
both victim as well, because now victim has to be brought
At the center stage. And Mr. Pankaj, I called you because of the reason that against the order of children's court,
appeal.
appeal is made.
single 6 and 7, I was very plain leadership that it will be taken up in the second half and post leadership.
6 and 7.
Yes, leadership. I'm facing an embarrassing situation, leadership, that my eyes are not clear.
But in this case, man, the victim is, I have case, man, the victim has not examined already. One witness has been, maybe called for the 183 statement of the victim.
183 may be also called leadership. In both the cases arises of the same FIR leadership and the same.
This is a case of gang rape, man.
That is
ये तो सब पहचान ही रहे हैं.
leadership.
He is the person who has identified, no? Because the lady says, because
I know that
he is the person, the husband has identified all the persons.
leadership, this case has all the important elements of the serious offense, and at first even I was little hesitant, but if
Victim
the
has been
180
examined.
no, leadership, 183 is called leadership.
183 से क्या होगा?
I will tell leadership because
Rape
if
हुआ है कि
I
नहीं
say
हुआ?
this with some sense of responsibility, leadership, that it appears that there is some fabrication. I cannot make out what is the fabrication. Why I say this, leadership? Because victim herself says that she is of 19 years old. Then, leadership, there is a statement that her age changes to 16 years. And then
How
there is
does that make it?
further
Rape हुआ है?
further, even the manner of the presence of the accused person, as stated by the victim in FIR and in by the husband and all the witnesses, are differing at different stages. Leadership.
You see, trial has commenced.
Leadership, that has commenced.
We can expedite your trial. It's a gang rape case. You see,
I am
इसमें
aware,
से
leadership,
selective नहीं हो सकता है. 183 का statement के
I am
basis
aware,
में in a
leadership,
case
and
of gang
that's
rape
why I
it is
said
very
leadership.
difficult.
It is a heinous offense. It
It's
has
a
all got
very serious offense.
If leadership posted in the second half, I will resist to leadership.
Okay, you come in the second half, but in the case of gang rape, when the examination of witnesses have commenced, victim is yet to be examined. 183 का statement में क्या करेंगे?
Leadership can be examined or not, because
No, they
this
are not.
order, leadership, the impugned order is of 6th February 2026.
See, even if the victim has been examined,
Leadership.
right, unless she turns completely hostile,
Leadership, what is her statement?
we
That
do
has-
not know. You see,
that has
we are not conducting the trial. It is for you to inform the court.
Leadership.
In anticipation whether she has been examined, not examined, you are here with the fabricator, and it is the duty of the fabricator to inform this
This
court.
has come from hypothetical source.
That's right.
It has come from legal aid, and even
Legal aid, but still you
I was
get,
going through all the online records also, leadership. It says the order, but it does not show whether it has initiated been happened, what is the status. And that is the only difficulty I am having.
in legal aid also you get connected to the
Leadership,
DLS.
I got to
You are entitled to know the status of the case. You are entitled to so many things. Please don't tell me that you are helpless because you are in legal aid.
leadership. I had tried leadership even while just few minutes ago of leadership. I was searching online, and nowadays they are uploading even a short order, so it is very much apparent what is there. But in this case particularly, leadership, those orders did not open. The link is not there.
You come in the second half.
Leadership.
You in the second.
Leadership.
ऐसे adjourn नहीं होगा. Gang rape
नहीं, leadership.
में-
Adjournment, that's why I prayed leadership for
कोई
second
बात
half. It was the APP who prayed for 180.
No.
I did not.
आइए second half.
Right.
Item 7, BS 7311 of 2026.
अच्छा ये भी साथ में दोनों को.
Item 8, BS 7315 of 2026.
क्या जानते हैं? What do you want?
At para 22 has stated कि पिछले करीब 26/5/26 से अभी तक 10 डेट हो चुके हैं, आर्गुमेंट नहीं चल रहा, ट्रायल में
कब से?
26/5/26 5 से 26 para 22 है, पर उसके बाद का डेट फाइलिंग के बाद का भी डेट्स है 13/7/26 21/7/26 30/7/26 11/8/26 and next date is 19/8/26 para 22 and stated notes.
Para 22 and see. Next date is
Next date is 19/8/26.
किसका आर्गुमेंट का? प्रोसिक्यूशन का आर्गुमेंट चल रहा होगा।
Your side.
ये स्टेट आपका वकील साहब बहस नहीं कर रहे हैं कोर्ट में। नहीं, कोई फाइल का कोई काम नहीं है, इसमें बहुत सिंपल सा है। पहले कई बार रिजेक्टेड है, लेकिन कई बार डेट्स हो चुका है, बट द मैटर इज नॉट बीइंग आर्ग्यूड बाय द प्रोसिक्यूशन इट सीम्स। तो आप अपने एपीपी को बोलिएगा बहस करने। पेज नंबर 20, पैरा नंबर 22।
यस मैम। आप इन्फॉर्म करते हो ट्रायल कंप्लीट करने के, ट्रायल कंप्लीट हो गया मैम मोर आर्गुमेंट है हमारे,
आर्गुमेंट पर है ना, तो आप कितना डेट से कितना डेट में
इन्फॉर्म
आर्गुमेंट
करते हैं कोर्ट भी लोगों की भाई
ठीक।
भाई दर्शन दे दीजिए हम लोग।
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the bail application of the petitioner was rejected thrice earlier. However, the petitioner has renewed his prayer for bail in view of his custody
Also more than 3 years.
Custody since
4/6/23.
Since 4/6/2023. He has submitted that the statement of the accused under section 313 CRPC was recorded on 25/3/2026. Thereafter, the case has been pending for argument from 26/5/26 to 26/5/26, 5/6/26, 10/6/26, 17/6/26, 23/6/26, 3/7/26, and on instructions he submit that the next date is on 19/8/2026.
Which dates?
He submits that there has been a few more dates between 3/7/26 to
That I can
19/8.
see. That I can see.
3/7 के बाद
3/7 के बाद 13/7/26.
3/7 के बाद 13/7/26,
21/7/26.
21/7/26,
30/7/26.
30/7/26,
11/8/26.
11/8/26,
And next date is 19/8.
and next date is 19/8/26. सारे dates नोट कर लिए भी यहाँ पे लिखा हुआ भी है। The learned counsel for the state has submitted that he shall take steps so that the concerned APP is instructed to ensure that he argues the case before the court. And trial is taken to a logical end at the earliest. After hearing the learned counsel for the parties and considering the fact that the petitioner is in custody since 4/6/2023 and the statement of the accused was recorded way back on 25/3/2026 and the case is being adjourned from time to time for the arguments of the prosecution. And since the trial is at fag end, this court is not inclined to enlarge the petition on bail. However, the matter cannot be lingered in the manner it has been done in the present case. The counsel for the state is directed to take appropriate steps and inform the SP of the concerned district so that the concerned APP in the court argues the case without unnecessary adjournment. The next date, as mentioned by the counsel for the petition, is on 19/8/2026. The learned trial court is also directed to expedite the conclusion of it.
Item 9, DA 7320 of 2026. Item 10, DA 7327 of 2026.
In this case, you are playing on behalf of victim notes are request to file your counter affidavit. Since your charge sheet has also been submitted under POSCO Act 4 and 6 of the POSCO Act, and the man please to call for this. Since the FIR was not under POSCO, but subsequently material collected, and thereafter charge sheet and provisions have been taken under 4 and 6 of the POSCO. It is based on the section 69 and 89 of the BNS law. So charge sheet has been submitted.
आप कब से custody में?
Only service.
Charge sheet तो नहीं हुआ, हो गया.
And charge sheet है 4 and 6 of the POSCO Act constituting
His lordship sees married lady on the false pretext of marriage. He has alleged that
Charge sheet अगर पॉक्सो में हो
हाँ,
गया तो क्या
POSCO में
करें? नहीं देखें. The learned counsel for the parties are present. The learned counsel for the informant has submitted that charge sheet has been submitted in the present case on 19/6/2026. Which
charge sheet नहीं हुआ है custody में है.
sorry, charge sheet has been submitted in the present case, including offence under POCSO Act. Victim का statement record किया.
164 में.
Office is directed to call for the case diary from the concerned court along with its enclosures, and also the statement of the victim recorded under section 183 BNSS. The counsel for the state is directed to file counter affidavit on witness. अब फाइल किए काउंटर नहीं किए ना अभी तक.
फर्स्ट है हमारे.
FSL भी है इसमें कोई. इसमें FSL है काउंसिल.
FSL का नहीं.
नहीं FSL नहीं.
चलिए next.
Any date will proceed.
Yes, please. The counter affidavit be filed by 21st August, post on 24th.
Item 11, DA 7334 of 2026.
The suspicion made the accused in this case no material in this case, and the co-accused has granted the bail under the court laws. The FIR is lost in
क्या स्टेज है कस्टडी कब से है?
custody में अब 8 महीने से है और पूरी में
डेट ऑफ कस्टडी बताइए.
3 जनवरी 2026 हम स्टेटेड के 12 में.
और अभी एविडेंस चल रहा है, क्या चल रहा है?
एविडेंस तो we have एविडेंस के स्टेज पर है, एविडेंस आया नहीं है, और इसमें जो और भी है सप्लीमेंट्री चार्जशीट हुआ है उसमें और प्रकरणों को फंसा दिया है. 15-20 आदमी और इसमें जो है एक ट्रेलर रीड किए थे, उसके बाद 15-20 आदमी और हमारे पास में कुछ भी नहीं है. सिर्फ हमको सिर्फ संदेह के आधार पर हमको दिया गया है. दूसरा वहाँ कोर्ट से बेल हो चुका है. कॉपी को दे रहे हैं. कोई कुछ कर
Birsa Ora is the main accused.
Yes, कोई कुछ named FIR. I'm also named the person.
आप कहाँ थे इतना दिन?
Yes, person.
इतने दिन कहाँ थे आप?
हमको तो कुछ था ही नहीं कि 2 साल के बाद हमको पुलिस बोल रही कि आपके ऊपर केस हुआ.
You are named accused.
Yes, I am named accused. क्योंकि पुलिस को पहले भी सस्पेंशन था कोई मेडिकल
आपको आपके ऊपर 82, 83 नहीं हुआ?
नहीं वो तो हम तो जेल में हो गए
नहीं, उसके पहले,
उसके ऊपर
क्योंकि आप तो 3/1/26 से जेल में है ना, केस तो 23 का सेम गांव के
हाँ सेम गांव के कोई रीजन है उड़िया में कोई फिटनेस में भी हमारे पास नहीं है 12
आपका नाम कहाँ बने FIR में?
हमारा नाम है पर
क्या नाम है?
नाम
मंगरी लग
हमारा नाम है हम 6 हैं सी नंबर 6
और इन पांचों का बेल हो गया?
जैसे दिशा गांव का होगा 21 नंबर 4 ये रेडियो के पास नहीं दिए हुए उसका
The learned counsel for the state is directed to seek instructions and file contract agreement. Let the case diary along with its enclosures be called for from the consent court, along with the stage of office.
इसी से और दो है
बिना कौन सा
इसी से 35 और 37
35 37 ठीक है. Tag this case with वो serial number 35 and 37 which arise out of the same FIR. तीनों में काउंटर और केस डायरी कॉमन ऑर्डर ड्रॉपर. बाकी दोनों में कौन है खबर कर देंगे आप? ठीक. उनका अगर आ जाएंगे तो उनका अपीयरेंस हम रिकॉर्ड. कौन है? मिस्टर विशंबर शास्त्री. दोनों है क्या?
Item 35 and 37.
35 and 37 ठीक है. उसमें दोनों में काउंटर फाइल करिए. केस डायरी मंगा रहे हैं. कई कोई कुछ का बेल हो चुका है. देख सकते हैं केस डायरी. कोई स्पेसिफिक इनके अगेंस्ट में हो तो
कुछ नहीं मैडम कुछ है ही नहीं.
अरे भैया आपको विश्वास कर रहे हैं इसीलिए केस डायरी मंगा रहे हैं. सिमिलर फुटिंग पे होगा तो ऐसा थोड़ी आपको बेल देंगे. हाँ. Let the counter affidavit be filed by 21st August, post on 24th.
Item 12, BA 7339 of 1026.
The offences are 1031, 61 to 35 of the BNS, in section 3(4) of the dowry prohibition. Subsequently, after investigation, the charge sheet has been submitted under section 108 and 3/5 of the BNS. My humble submission would be, since the so far demand of dowry and torture that has not been found to be true and the charge sheet has been submitted under section 108 of the BNS, the case diary would be necessary.
What is the stage? Charge sheet has been.
Charge sheet has been submitted.
You are the husband.
I am the
You are the informant. ठीक है. केस डायरी देखो.
Because it has come that there was some domestic issues with the mother-in-law.
We'll figure it out.
And out of.
We'll figure it out. Counsel for the state is directed to seek instructions and file counter affidavit. Let the case diary along with its enclosure, including the postmortem report, be called for from the concerned court. The counter affidavit be filed by 21st, post on 24th. Counsel for the informant is present.
FSL has also not been received.
Okay. The counsel for the state is also directed to seek instructions and produce the FSL report in sealed cover. FSL में I think वहाँ पर भी एक होना चाहिए for the purposes of recording of evidence through BC, FSL में and RIMS में भी होना चाहिए for postmortem के लिए वहाँ से
उससे
direct
बहुत सुविधा हो जाएगा for the persons over there. So basically, in most cases, we see that the reports are marked
exhibited
exhibit
ऐसे
and
ही हाँ marked exhibit ऐसे ही हो जाता है, cross examination नहीं होता. We'll figure it out if it can be worked out.
because the recent judgment of the Honorable Supreme Court suggests that there should be examination
It has
of
to
the
be there.
experts.
But आपका जो expert witness है उसका cross examination नहीं होने से दिक्कत दोनों तरफ से दिक्कत है क्योंकि prosecution की तरफ से भी दिक्कत है defense की तरफ से भी. Let us see, we'll figure it out if it can happen.
Item 13, PA 7343 of 2026.
Charge has been filed under 376(2)(n), 307 and 326(a). Much of the allegation is that this
Who have been examined? आप बताइए बाकी next date बताइए आपका trial ही conclude हो जाएगा.
the lordship two prosecution witnesses.
ये 13/6/25 को two have been examined. 13/6/25 उसके बाद
The lordship, I was checking online record, it was saying the same thing. The lordship, it is in the stage of evidence.
आपका trial yes state. You see, he is making a statement कि 13/6/25 को दो witness examine हुए हैं. अभी तक भी दो ही witness examine. Very serious. Next date बता दीजिए आपने वो भी तो देखा होगा ना. Next date का.
Next hearing date is 17th, 48/2026.
तो बहुत short है अभी. The learned counsel for the petitioner submits that in the present case, charge was framed against the petitioner on 14/8/24 under section 376 within bracket 2 within bracket n, comma 307 and 326A of IPC. And as per the improved order dated 13/6/25, two prosecution witnesses have been examined. And he further submits that thereafter no prosecution witness has been examined. And the petitioner is in custody since
21/3/2023.
21/3/2020. The next date in the case is on 14/8/2026.
And reason for adjournment is witness not produced by prosecution.
He submits that the reason for adjournment from time to time is that witnesses are not being produced
By
by the prosecution. The learned counsel for the state, while opposing the prayer for bail, has submitted that there is direct and serious allegation against the petitioner, and therefore the petitioner may not be enlarged on bail. However, she submits that appropriate steps will be taken for the production of the remaining witnesses. कोई FSL है इसमें?
No, lordship, she has no medical examination has been done. She refused to.
There was an acid attack also.
Yes.
The learned counsel submits that the victim also suffered acid attack
And she has
and lost vision in her left eye. After hearing the learned counsel for the parties and in view of the submission made by the learned counsel for the petitioner that witnesses are not being produced before the court, The fact remains that the allegation against the petitioner are very serious. In such circumstances, this court is not inclined to enlarge the petitioner on bail. However, there can be no excuse on the part of the prosecution not to produce the witnesses before the court. The state is directed to ensure that the remaining witnesses are promptly produced before the court. The counsel for the petition has already informed that the next date of the case is 14/8/2026. The counsel for the state is directed to communicate this order to the SP of the concerned district and to the director prosecution to ensure compliance. Absence नहीं होना चाहिए मैडम विटनेस।
Item 14, DA 7352 of 2026.
Yes, petition.
Case has been registered in 103 of 103 and 35 of the 3 and 2 of the petition has been released in the case 14 is the FIR. Case 14 is the which is the FIR. This petitioner is not named in the FIR.
Not named. The counsel for the petitioner submits that the petition is not named in the FIR and he is in custody since
19/6/2026.
statute. तब क्या इन्वेस्टिगेशन ही नहीं कंप्लीट हुआ तो क्या होगा?
नहीं चार्जशीट किया इन्वेस्टिगेशन
अभी बहुत टाइम है ना?
नहीं टाइम कहाँ है? 2 महीना तो 2 महीना उससे कम में ही सबमिशन हो जाता है चार्जशीट।
The petitioner is in custody since 19/6/2026.
कुछ एविडेंस नहीं है ऑनली कन्फेशन। पैराग्राफ रेफर्ड है उसमें मेन इश्यूज है उसी के बारे में बोला गया है हमारे पास डिस्क्लोज है वो इश्यूज के कंडीशन से सिर्फ बनाना इन्वेस्टिगेशन हुआ तभी हमको
लास्ट वाला में आया जजमेंट रिएक्शन ऑर्डर
पैरा 99 ये तो वो है इनके अगेंस्ट में क्या है? Not named statement of
पेज नंबर 21 में है
सिर्फ कन्फेशन
में है petitioner name reported by the petitioner and statement reported by party of the case that is where it is disclosed about the involvement in the manner of as the involvement of the co-accused.
इसमें भी मेरा नाम है।
That's right. The learned counsel for the state has submitted that though the petitioner is not named in the FIR, but investigation is still going on. And the alleged offence is heinous offence.
इसको रिजेक्ट
Of course, reject.
मतलब चार्जशीट हुआ हमारे पास कोई
चार्जशीट हो गया है।
चार्जशीट नहीं हुआ है लेकिन इन्वेस्टिगेशन मेरे अगेंस्ट में पेंडिंग है मेरे अगेंस्ट में इन्वेस्टिगेशन पेंडिंग कोई एविडेंस नहीं है
एविडेंस तो इन्वेस्टिगेशन में आएगा ना?
इन्वेस्टिगेशन में आएगा इन्वेस्टिगेशन हुआ तब तो हमको पकड़े नहीं तो हमको क्यों पकड़ते अगर कुछ कंप्लीट नहीं हुआ था नेम्ड होते तो कोई बात था तब चार्जशीट का जरूरी होता लेकिन विदाउट इन्वेस्टिगेशन हाउ कैन आई बी अरेस्टेड
अभी आपका इन्वेस्टिगेशन
if there is no evidence against me there must be some investigation
आपको अरेस्ट करने के बाद इन्वेस्टिगेशन खत्म हो जाता है वहीं पर
if there is
upon
some
your arrest the investigation is over
ऐसा नहीं है खत्म नहीं होता है
after hearing the learned counsel for
हम
the
विड्रॉ कर लेते हैं
and considering the fact that there is
ऐसे कैसे रिजेक्ट और सब केस में तो मैं आप देती हैं रेगुलर बेल है ये और चार्जशीट रहता है ऐसा नहीं है कि चार्जशीट पेंडिंग रहता है
ऑर्डर सुनिए
मैं ऑर्डर सुन रहे हैं
चार्जशीट कहाँ सुने
चार्जशीट
कहाँ सुने हैं
चार्जशीट अभी जब पेंडिंग है हमारा मेरा चार्जशीट अभी नहीं हुआ है ऐसा नहीं है कि सब केस में चार्जशीट नहीं होने से बेल रिजेक्ट हो जाता है विदाउट कोई एविडेंस ऐसा तो नहीं होता है
इतना हीनियस ऑफेंस में
Heinous
आपके
में-
अगेंस्ट में इन्वेस्टिगेशन पेंडिंग है, should I leave you to influence the other witnesses?
कहाँ लिखा हुआ है कि I am influencing him? I am
लिखा हुआ है
custody.
क्या? This is all likelihood that you will
डायरी
invest.
में डायरी कॉल पर कर लिया जाए
नहीं
तो उसको हम विड्रॉ कर लेते हैं कि आपको
After some
सबमिशन
arguments, when this court was not inclined to enlarge the petitioner on bail, the petitioner seeks permission to withdraw this bail application. Accordingly, this
with
bail
liberty
application
with liberty
liberty तो आपको रोज फाइल करना
रोज फिर लेकिन since charge sheet has not been submitted
लिख दीजिएगा इनके सबमिशन में, since charge sheet has not been submitted. इतना सीरियस ऑफेंसेस में आप लोग को एज ए काउंसिल भी सोचना चाहिए
serious offense
कि
है there is
investigation-
I witnessing the occurrence
एक बात बताइए, just a moment.
पहला तो ये क्राइम अगेंस्ट वीमेन नहीं है
तो आप इसको तो फिर आप जाइए चीफ साहब को बोलिए कि ये क्राइम अगेंस्ट विमेन नहीं है, विचक्राफ्ट एक्ट है लेकिन क्राइम अगेंस्ट विमेन नहीं है।
विचक्राफ्ट में जेंट्स नहीं होते हैं क्या?
नहीं जो भी है आई डू नॉट नो। देखिए हमारे कहने से तो केस लिस्ट में नहीं आया है। जस्ट अ मोमेंट, आई एम नॉट इंस्ट्रूमेंटल इन लिस्टिंग ऑफ दिस केस। यू गो एंड टॉक टू द ऑफिस एंड फाइंड इट आउट कि कौन सा केस कहाँ जाएगा नहीं जाएगा, ठीक है। इसलिए ये जो आप ये पूरा बहस करने के बाद बोल रहे हैं क्राइम अगेंस्ट विमेन नहीं है, तो बहुत सीरियस बात, ठीक है। लेडी को मार दिया गया है।
लेडी को मारा नहीं गया, जेंट्स का मर्डर।
लेडीज को भी मारा गया,
जेंट्स का मर्डर है, जेंट्स का एक मर्डर हुआ है। आई विटनेस है, उसमें हम प्रेजेंट नहीं है।
विचक्राफ्ट में लेडी के ही अगेंस्ट में विचक्राफ्ट का केस होता है, मतलब
दोनों के अगेंस्ट,
मतलब जो विचक्राफ्ट एक्ट है
हाँ।
उसमें किसी जेंट्स को भी डायन बोला जाता है क्या?
दोनों के अगेंस्ट में हो सकता
नहीं,
है।
हम जानना चाहते हैं
और भी उसमें
विचक्राफ्ट
techniques-
एक्ट में जेंट्स को भी डायन बोला जा सकता है क्या? थोड़ा एग्जामिन कर लीजिए अच्छे से, बोलने के पहले थोड़ा सोच समझ के बोला जाए।
Item 15, BA 7355 of 2026.
Yes, petitioner.
Yes, my lord, may I please your
Yes.
petition? My lord, leadership may kindly come to the FIR for a while. It is at page 15.
Yes.
I'm reading it, ma'am. सविनय निवेदन पूर्वक कहना है कि मैं सच एंड सच उम्र सच एंड सच थाना सच एंड सच की रहने वाली हूँ। मैं बड़ी गोड़ी स्थित नाइस पब्लिक स्कूल में 8वीं कक्षा का छात्रा हूँ। दिनांक 24/4/2026 को 11 बजे मैं अपने स्कूल को अपने प्रधान अध्यापक के ऑफिस में अपना मार्कशीट लेने के लिए गई थी। जब मैं अपने प्रधान अध्यापक जिसका नाम इमामुद्दीन अंसारी पिटिशनर बिफोर योर लॉर्ड पिता सचिन सच थाना सचिन पचम्बा में अपना मार्कशीट मांगी तो उन्होंने मेरा मार्कशीट दे दिया। इसके बाद मैं अपने घर जाने लगी, तभी इमामुद्दीन सर ने मुझे आवाज लगाकर फिर से अपने कक्षा में बुलाया। तब मैं फिर से अंदर चली गई। जैसे ही मैं प्रधान अध्यापक के कक्षा में अंदर गई तो इमामुद्दीन सर मेरा मुंह दबाकर मुझे जबरदस्ती पकड़कर मेरे साथ छेड़खानी करने लगे और मेरा सर मदलने लगे। मुंह बंद होने के कारण मैं चिल्ला भी नहीं सकी। जब मैं उनकी रोकने की कोशिश की तो वो मुझे धमकी देते लगी कि अगर इसके बारे में तुम किसी को बताओ तो तुम्हें स्कूल से निकाल दूंगा। इसके बाद मैं किसी तरह का अपने आप को छुड़ाकर वहां से भाग गई। घर आकर अपने परिजनों को सारा बात बताई। मैं तथा घर वाले काफी डरे सहमत थे। इसके कारण आवेदन आज दे रही हूँ। ये घटना श्रीमान अनुरोध है कि उस घटना की इस पर कानूनी कार्रवाई की कृपा किया जाए। Yes, now, Lord, leadership may kindly see Annex 2 for a while. It is the attendance register of the school, my lord. This school is running for last 15 years. Certain statements I have given, my lord, on 500 rupees. I all the poor villagers, this school is giving party education, my lord. And thereafter, if Lord, this place of operation is 24/4 and the FIR has been lodged after 2 days delay. Now, an Annex 2 may kindly be seen. That is the attendance register, my lord.
Okay. Yes.
Annex 2, page 18.
Yes.
The date is 22nd April. She was not present on 22nd April. On 21st, she was present.
This attendance register has been seized during investigation.
My lord,
Has it been,
investigating
you see,
officer.
this is the attendance
That
register.
I'm not aware of that one, whether seized or not. One statement may kindly be seen, my lord.
I am not able to find out what is the date of attendance from here. I'm not able to find out the date of attendance. Which
It's
page are you
not-
referring to? Para number 18?
Page 17.
Page 17?
17.
Okay, this is for the month of April 26.
Yes.
Okay. This
And
is
the date of occurrence is 22/4/2026, the 22nd April 2026.
the name of the students is not mentioned over here. How do we know?
It was mentioned on page 16.
So that side, my lord.
Serial number 2.
Page 16, the name of students is
Right.
mentioned.
Class 9, all students'
I
name
would
is
like to
mentioned,
mention-
Janvi, then the second name. Second name, so
Second name is Shobha Kumari. That was the-
and one more, I was every time saying there is a CCTV footage, my lord. Then you please collect this CCTV footage from, and the IO deliberately has not come, and after 1.5 months, the IO is going to collect it, and at that time CCTV footage is not there. And the
You should
IO
have-
has
you
been
should have saved
suspended
it.
because of this, my lord.
The
I'm only
CCTV,
saying the
just a
183
moment,
statement.
you are the principal of the school, right?
Yes.
So it was certainly within your limit and within your jurisdiction to save the CCTV footage, even if the IO is not collecting. What steps have you taken to save the CCTV footage?
Lady, we have a CCTV footage. Right, we can produce a CCTV, but
Produce means?
I have said, stated
That is safe. That is safe in the my pen drive. It is safe, but the police is not collecting it. That is safe, my leadership. No,
In your
if
pen
you want that, then I can produce that pen drive also. That I have saved. That pen drive is there with me. I am trying to give it, but the police is not collecting it. The IO, and this IO for implicating 2% has been suspended very recently, man.
Charge sheet has been filed against you?
Yes.
You have that 65B certification?
That certification, my lord, I have, but that certification I have to provide, my lord. That certification I am trying to give
Where
it to
have
the
you
IO.
annexed it and where it is mentioned that you have the CCTV footage with the 65B certification? And 65B certification has to be done after verifying it from the original.
Yes, yes.
Now the original is not there.
In the land through which it is connected, all the computers were in or
That's right.
workable position. That's
So now you say that now when the IO went to the school, that CCTV footage is not there.
After 1.5 months.
Maybe after 1.5. You see, if anybody wants to save the CCTV footage, for that he need not take it down to his pen drive. It can be saved in the system itself as a primary evidence. If the primary evidence is
para 53,
you just tell us.
the
If the
investigation
primary
want to
evidence is
retrieve
not
the CCTV,
available,
but the same was not provided to me as the videos are gone for digital video recorder DVR, as the said DVR does not have the capacity to retain the old videos.
no, it is, you see, the CCTV footage, if anybody wants to retain it, it will be retained in the system. If you take it out in your pen drive, how will you certify it?
Because from the system, if I am
The-
taking
the-
out
the
in the pen drive and connecting it to the lab.
You see, the original is destroyed. It is not there. Is it available to you? Original is available to you? No.
That's true.
That's a fact. Original is not available. You cannot have this certification 65B.
If the original is not available, then the 65B will not come into play, my lord. That is true.
That is
Then
true.
the primary
So
evidence
therefore-
that has to be brought. Primary evidence has
That
to be
has,
brought.
yes.
Then the original computer has to be brought on record and if it is stored. But only one thing, the main girl
You see,
who
Mr.
was
Mr.
accompanying.
Sakya, you please appreciate. He is a principal of a school,
True.
right? So many students are there. So it is
Not.
and a direct allegation against him. It's something
For
very serious.
15 years, I am the nobody has.
You see, I can appreciate that, but the point is that there is absolutely direct allegation against him.
My leadership in villages, the politics is so much there for a false implication. A few days back, three trials have gone, my lord, in all accurately POSCO matters, leadership. In villages, for tribal things, they go on and do this. It's true that leadership will understand why somebody will falsely implicate a person on the behalf of the prestige of the daughter who has to live for the entire life. These all things, but in villages for tribal matters, these are things that are being done. And this misuse of POSCO Act is being done.
What
and
is
there is
the-
a delay of 2 months.
You see, that is why. That is why.
2 days delay, my lord, and why after 2 days the fair gone? And prior to that, the fair was there.
You have not mentioned that there is any kind of otherwise there is any dispute with this girl. Nothing. There is no dispute with this girl. Is there any dispute with this girl or her parents, or there is any kind of politics or any kind of rivalry? It is not there. You just tell me. You just let me. What is the stage? What is the stage of the case? Stage. What is the stage of that? Stage.
My lord, the charge sheet has been framed. The charges are must not yet to be framed. I'm only saying that I will be in custody. Only the case date is if it can be, and a very small date may be fixed, my lord. And nothing on that, my lord. Because I also don't have the case diary. If he produces it for a while.
That she is student of class 8 and the attendance register is of class 9.
Attendance register of
class 9.
Sabishaki verify.
Heard the learned counsels appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case, and there was delay of 2 days in lodging the FIR. The petitioner is in custody since 25/4/2026, and charge sheet has already been submitted. He has further submitted that along with the bail application, he has annexed a copy of the attendance register and the informant who happens to be the student in the school in which the petitioner is the principal was not present on 22/11/2026. The learned counsel for the state has opposed the prayer for bail and has submitted that there is direct and specific allegation against the petitioner, which has been lodged by the student herself, and the attendance register which has been produced by the petitioner relates to class 9, and she has stated that the victim has stated that she was studying in class 8. The allegation is that the victim went to collect her mark sheet from the petitioner, and after getting her mark sheet while she was going back, the petitioner called her again and committed the alleged offence. After hearing the learned counsel for the parties and considering the direct allegation made against the petitioner, who happens to be the principal of the school in which the victim, aged 14 years, was studying, this court is not inclined to enlarge the petition on the institute. Mr. Kaushik Sarki has appeared online.
Item 16, DA 7359 of 2026.
Yes, petitioner. Sorry?
Item 17, BA 7366 of 2026.
Yes, petitioner. Who is the informant of the case?
The informant is the brother, said to the
Informant is?
Karuna Devi.
Who is the victim, I said?
No, victim of Mausi. यह कि मैं विजय मानता हूँ 1600 धनबाद निवासी आज दिनांक को लगभग रखा मेरी मौसी की लड़की.
Okay. That's right. We'll call for a statement. And
I also rely on the word medical because there is no sign of anything. And
we'll
this
call
is-
for it.
Yes, yes. No, there was medical and 164 also.
Charge sheet submitted.
Charge sheet submitted.
Counsel for the parties are present. The learned counsel for the state is directed to serve notice upon the informant of the case and file a counter affidavit on the merits. Let the case diary along with its enclosures be called for from the concerned court, and also the statement of the victim recorded under section 183 basis. The counter affidavit be filed by 21st, post on 24th.
Item 18, BA 7369 of 2026.
Earlier we were rejected, but now time same circle, both party are ready to marry each other. We taken after one wedding. Although there is no case is not compatible, but both party are ready to marry with each other.
Okay, do you see?
The affidavit has been filed before the late court window minor and tomorrow is date fixed.
लड़की का उम्र क्या?
अभी तो 19 years.
She became pregnant, gave birth to a child also.
Yes.
What was the age of the victim at the time of commission of offense?
17 years.
17 years. कोई लव अफेयर का कहानी तो है नहीं?
लव अफेयर था एक दोनों का घर हमारा गोदाम था इनके घर के सामने और इनके पिताजी हमारे यहाँ काम भी करते थे. इसी बीच जो हुआ उनका एलिगेशन है.
Victim का evidence हो गया?
जी.
Victim has been examined before the court
Examined.
as PW.
PW1.
She has supported or not supported?
Supported me.
If she has supported तो फिर इसका आपका शादी करने के लिए तैयार है, इससे क्या लेना देना?
नहीं तो वो भी तैयार है, एक बच्ची भी है.
भाई तैयार है शादी करने के लिए, सब चीज ठीक है, लेकिन ऑफेंस तो कंपाउंडेबल नहीं है ना. She has supported the prosecution case.
कंपाउंडेबल नहीं होगी, इसी अभी वहाँ
शादी करने का ऑर्डर क्रिमिनल केसेस में थोड़ी होता.
नहीं वो तो वहाँ मैंने दोनों पार्टी दिए हैं.
ये पावर सिर्फ ऑनरेबल सुप्रीम कोर्ट को.
हाँ तो वहाँ
142 में
वहाँ दिए हैं ललित ट्रायल पर दोनों पार्टी दिए हैं.
कितना विटनेस एग्जामिन हुआ?
5 out of 8 5 है एग्जाम.
नेक्स्ट डेट कब?
नेक्स्ट डेट कल है.
कल यानी कि 13 तारीख.
जी
13 तारीख.
जी.
कौन कौन बच रहे हैं? आईओ डॉक्टर
और एक और कोई दोनों सेम कास्ट के हुजूर बच्ची भी है और आपसे ही मैंने 12 विषय के बीच हुआ कि लड़की भी बालिग भी हो गई है.
शादी करने के लिए तैयार है आफ्टर शी हैज सपोर्टेड द प्रोसिक्यूशन केस, तो क्या बोलेंगे बेटा?
कि पहले से ये लोग का इंटेंशन नहीं था कि शादी हो जाती तब ये केस होता ही नहीं।
ऐसा तो एफआईआर में नहीं।
नहीं ऐसे ही हम लोग किए हैं, बोले भी कहीं कोई सूचना नहीं दी, पहले सारा होते रहा, कभी लड़की कोई कहीं कंप्लेंट किए नहीं।
पहले भी आप लोग का मेरा जबरदस्ती ऑपरेशन कर बच्चा निकाल लिया, और क्या क्या कहानी है आपके एफआईआर में, हम देख रहे हैं।
हाँ तो जो है तो वही है।
2-4 बार हो चुका है कहानी, उसके बाद एट लास्ट शी हैज गिवन बर्थ टू अ चाइल्ड।
शुरू से इंटेंशन यही था कि शादी अगर हो जाती तो केस नहीं।
इंटेंशन यही था, तब ये बच्चा बार-बार निकाल के काट
नहीं निकाला नहीं, ऑपरेशन हुआ, डिलीवरी हुआ है। हमारा इतना गलती है कि मान ली हम जो बात का स्टोरी
आपका ट्रायल हम एक्सपीडाइट करा सकते हैं, इसके अलावा हम आपका शादी का ऑब्जर्वेशन यहाँ से नहीं दे सकते।
तो एक नेक्स्ट वीक देख लिया जाए जो
और the learned counsel appearing on behalf of the parties, the learned counsel
पर्पस सॉल्व नहीं हुआ, ले दोनों पार्टी रेडी है।
पर्पस सॉल्व होगा जब कल्प्रिट को सजा हो,
तो उससे क्या
पर्पस तभी सॉल्व होगा।
करियर तो दोनों का, एक बच्ची भी है उसका भी करियर चौपट हो जाएगा। ये दोनों का करियर तो चौपट होगा, ये बच्ची जो है उससे उसका भी करियर में कौन शादी करेगा उससे। हम इसीलिए बेल भी सर इसीलिए आपसे पंच समझौता से हुआ कि नहीं शादी करेगा, रेडी है बच्चा शादी करने के लिए दोनों, और उसके लिए कंपनी वहाँ डाला भी है, स्टेटमेंट भी देने को भी तैयार है।
The learned counsel for the petitioner submits that the bail application of the petitioner was rejected earlier in DA number 6184 of 2025 by order dated 24/7/2025. The learned counsel submits that the trial is going on, and out of 8 charge sheet witnesses, 5 have already been examined. The next date is on 13/8/2026. He has submitted that the petitioner is ready to marry the victim. The learned counsel for the state has opposed the prayer for bail and has submitted that victim was minor on the date of alleged offence, and she also became pregnant, and the child has also been born, and there is direct allegation against the petitioner. After hearing the learned counsel for the parties and considering the fact that the trial is going on, this court is not inclined to enlarge the petitioner on bail on the submission that the petitioner is ready to marry the victim. However, the state is directed to produce the remaining witnesses promptly before the court concerned. The counsel for the state is directed to communicate this order to the director of prosecution and to the SP of the concerned district. Next. आप शादी करने के लिए तैयार हो, विक्टिम शादी करने के लिए तैयार है,
विक्टिम तैयार है, वो दोनों
जॉइंट कॉम्प्रोमाइज पिटीशन आप सुप्रीम कोर्ट में ही फाइल कर पाइएगा, क्योंकि ना इस कोर्ट को जुरिस्डिक्शन होगा इसको कॉम्प्रोमाइज करने का, ना ही ट्रायल कोर्ट को जुरिस्डिक्शन होगा।
बात मैंने पर्पस सॉल्व होगा, ये दोनों पार्टी का रेडी है, बच्ची भी
पर्पस सॉल्व होगा कि ऐसा इंसिडेंट्स नहीं होना चाहिए।
अब तो रिफॉर्मेटरी तो होना चाहिए ना, जो ये तो वाले दोनों सेम कास्ट के हैं, ये साथ बच्ची भी एक है, उनका भी भविष्य तो है।
Item 19.
Who is the petitioner?
Yes, Lordship, FIR is at least page 12, Lordship. Lordship, may see the page 12, the FIR this has been on.
Who is the informant in the FIR?
Informant is the father, Lordship. Lordship से सविता निवेदन पूर्वक करना है कि मैं गुंडा को 6/5/26 को शाम के 5 बजे मेरी बेटी सीमा कुमारी को
चार्जशीट हो गया?
या
चार्जशीट हो गया?
चार्जशीट जमा हो गई। इंप्यूड ऑर्डर में भी आया है जो कि 183 का स्टेटमेंट बोलते हैं कि लव अफेयर था, हम गए हैं पेज 16 में भी से 16
विक्टिम का एज क्या है?
जी ये जो फादर लिख रहे हैं 17 साल, लेकिन कहीं कोई मैंने डॉक्यूमेंट्री एविडेंस नहीं है। ये लोग वहां बनारस में ब्रिक क्लीन में काम करते हैं, तो वहीं से लव अफेयर था, पेज 17 में भी से जस्ट इन द मिडिल ऑफ इट।
The statement of the victim recorded in section 1 in the reveals she acknowledged the petitioner account of the loss. Just in the middle of the statement of the victim recorded in section 183 of the BNS reveals that she acknowledged the petitioner account of the loss. 38 दिन बाद FIR हुआ है, डेट ऑफ मर्डर से 6/5/26 और उसके बाद FIR हुआ है जाके 14/6/26 अब पिटिशनर है उसी दिन से कस्टडी
कब से
14/6/26 से 6/5/26 का इंसिडेंट है और 14/6/26 पे FIR हुआ उसी दिन से उसको कस्टडी में दे दिया। अब कहीं कोई डॉक्यूमेंट्री एविडेंस नहीं है कि इसका 17
चार्जशीट कब हुआ?
चार्जशीट इसका जमा हो गया है 30 जुलाई 2026 को। चार्ज फ्रेम नहीं हुआ है, चार्जशीट जमा हो गई 30/7/26।
कोई सेक्सुअल असॉल्ट का एलिगेशन नहीं?
कोई ऐसा नहीं।
183 में
नहीं कुछ ऐसा नहीं। तो देखा लिखिए कि से अपना डिफिनेशन अबाउट लॉ।
Counsel for the petitioner submits that charge sheet has been submitted and there was love affair between the petitioner and the informant and the victim. He further submits that victim has not alleged any sexual assault against the petitioner, although she was taken to Banaras. ये है ना?
बनारस नहीं गई है।
She was taken to Banaras. Let the statement of the victim recorded under section 183 BNSS be called for from the concerned court, along with the case diary and its enclosures. The learned counsel for the state is directed to serve notice upon the informant of the case and file a counter affidavit on merits. Let the counter affidavit be filed by 25, post on 24. देख लेते हैं उनका स्टेटमेंट, कोई सेक्सुअल असॉल्ट का एलिगेशन नहीं है तो आपको दे दें।
In the meantime, may I make a clear notice? The petitioner may be enlarged on
Item 20, BA 7375 of 2026.
terms of compromise between the parties.
अभी 183 का स्टेटमेंट लिखो। प्रोविजनल बेल देके कॉम्प्रोमाइज कराना बहुत लोग इतना कॉम्प्रोमाइज का बात करते हैं, हमको तो समझ ही नहीं आता।
इसलिए कि हम लोग
इतना कोई कॉम्प्रोमाइज का बात इस पॉक्सो में हो सकता है? I am absolutely clueless. What kind of compromise you are talking about? आने दीजिए। If there is no allegation of sexual assault, you will get bail. I'm telling you. अगर मेरा बेंच रहा और हम रहे तो
ऐसा क्या बोलते हैं? ऐसा नहीं बोलते हैं। बेंच नहीं है दूसरी बात है लेकिन ऐसा नहीं।
चलिए। What is the allegation?
96 8/12 In this case, charge sheet has been submitted against the petitioner under section 96.
ये क्या है? FIR पढ़ी है? अपने है FIR में? पढ़ी।
FIR में फादर किए हुए हैं।
हाँ, लड़की है।
हाँ, बच्चे के फादर।
भाई लड़की का स्टेटमेंट बिना देखे तो क्या ही कर सकते
हैं? इसमें उनका स्टेटमेंट का लॉ से काइंडली सी लॉ से
मंगा लेते हैं ना। 183 का स्टेटमेट बिना देखे नहीं करते।
कस्टडी में चार्ज मुझे फ्रेंड हो गया लॉ से।
अच्छा ठीक है, 183 का स्टेटमेंट मंगा के दे।
इसमें चार्ज है फ्रेंड लॉ से ऑन 7/1/2026 7/1/2026 एंड विक्टिम हैज नॉट बीन एग्जामिन्ड।
ये तो और ही गलत बात है। आपको पता है कि नहीं, 1 महीना में चार्ज फ्रेमिंग के विक्टिम को एग्जामिन करना होता है कोर्ट में। फिर क्या चल रहा है? तो बोले विक्टिम का एग्जामिनेशन नहीं हुआ 8 महीना होने के बाद, उसके बाद कॉम्प्रोमाइज होगा।
कस्टडी में है और सिर्फ 30/6/2025 से रोज।
यस मैडम, यू अंडरस्टैंड 1 महीना का क्यों है ये प्रोविजन? उसके बाद कॉम्प्रोमाइज हो जाएगा। Counsel for the just a moment. Counsel for the petitioner submits that the charge has been framed on 7/1/26. Still, the victim has not been examined. As per the provision of law, victim is required to be examined within 1 month from the date of framing of charge. The learned counsel for the state is not able to answer as to why the victim has not been examined so far. Let the statement of the victim recorded under section 183 BNSS be called for from the concerned court, along with the case diary and its enclosures and the stage of the case. clearly stating as to whether the victim has been examined so far or not. The state is directed to serve notice upon the involvement of the case and file a counter affidavit on minutes. The counter affidavit will be filed by 21st,
इसमें नोट से
post on 24. आप जो बोले हैं हम लिखाएंगे, अब रिकॉर्ड आएगा तब देखिए.
Item 21, BA 7377 of 2026.
I'm not pressing the petition.
The learned counsel submits that it does not want to press this bail application at this stage. Accordingly, this bail application is dismissed as not pressed. आप informant हैं? आप state हैं? Counsel for the state has no objection to the prayer.
Sign.
Senior counsel का नाम देंगे.
Item 22, BA 7386 of 2026.
Yes, petition. Who is the informant? Who is the victim, the informant of the case? Victim was recovered from where?
Railway station, Nimad railway station.
Along with the petitioner?
Yes, sir. इसमें 180 exam में उसमें मेरे
Victim was she was being taken to Hyderabad.
हाँ, एलिगेशन ले जाए, मतलब जा रहे थे हम लोग 180 BNS एग्जाम में बिल्कुल पुलिस लोग से उसमें मेरे अगेंस्ट में कुछ नहीं बोले हैं, मेरे साथ में कुछ नहीं वैसा भी.
चार्जशीट हो गया?
चार्जशीट भी हो गया है, चार्ज फ्रेम भी हो गया 24/7/2026.
अभी तक विक्टिम का एग्जामिनेशन है.
183 में वो मेरे अगेंस्ट में कोई एलिगेशन नहीं.
Counsel for the petitioner submits that though the victim is minor, but she has not made any allegation against the petitioner. Even in a statement recorded on section 183 BNSS. Charge has been framed on 24/7/2026. The victim has not been examined so far. The state is directed to serve notice upon the informant of the case and file counter affidavit on merit. Let the case diary along with its enclosures be called for from the concerned court, and also the statement of the victim recorded under section 183 BNSS and the stage of the case. The counter affidavit will be filed by 21st, post on 24th.
Item 23, BA 7390.
इसमें एक second. The counter affidavit be filed by 27th, post on 1st of September. तब तक हो सकता है victim का examination हो जाए. Okay.
Item 23.
109.
74 This is also related to the party job. I read that kind of page number 13. So we know that yeah, he met his hard side of the sir. आज नाम 21 से 24 10 बजे मेरे घर से निकलने में नाली का निकासी के पास बाकी जमीन पर मोहम्मद ताज जिसे पिटिशनर होती मोहम्मद मजहर मोहम्मद छोटू तीनों पिता मोहम्मद मुमताज ताज के द्वारा उस जमीन पर बिना मर्जी के जबरदस्ती बाउंड्री करना यह देखकर जब मेरी पत्नी शाहजहां परवीन और मेरी बेटी नीलू परवीन और खुशबू परवीन रोकने गई तो गुलशन परवीन उसकी छोटी लाडली जान से मारने के लिए सर पर मार दिया, उसे गुलशन भी करवा दिया और नियत खराब होने के कारण मेरी बीवी पर मेरी छुड़ानी मेरी बीवी और वह मेरी बेटी का कपड़ा फाड़ दिया. उसके बाद जब मेरा बेटा छुड़ाने आया तो मेरे बेटे को जान से मारने के लिए सर पर मारा, जिससे कारण में नाटक
चार्जशीट हो गई.
चार्जशीट नोट्स कभी बन गई. ये जो लैंड डिस्प्यूट का बेटा है और ये केस एनकाउंटर केस है. हमने इससे पहले जब 2 केस किया है, ये सच ये ऐसी बाउंड्री पर नाली का बाउंड्री मारने 2 भी केस किए, दोनों इसी पर है. एक कंप्लेंट केस है और एक एफआईआर जो इसके बाद हुआ है, जिन पर देखा जाएगा.
इंजरी कितना है?
इंजरी जो पेंडिंग दिखा रहा है शायद इंजरी रिपोर्ट, उसके बाद एक लेटर को अपने थाना में वो जो म्यूनसिपल बीपी है वो अपने कागज दिए है, एक्चुअली वो लिख के दिए है कि हम एक्सरे कराकर हम दवा खाकर निकल गए।
I need to file injury report because there is a head fracture also. सर की फ्रैक्चर हुआ है एक तो फिर
मारा कौन?
डॉक्टर शाह
कब से कस्टडी में?
कस्टडी में 21 से 26।
चार्जशीट नहीं हुआ है तो क्या बोले?
60
इंजरी रिपोर्ट नहीं आया है,
हाथ की फ्रैक्चर हुआ है।
क्या चीज देखकर आपको बेल दे बताइए?
एक्चुअली जो वहाँ बेल रिजेक्ट किसी को सिर्फ पेंडिंग पे वहाँ पर बिना इंजरी रिपोर्ट कहीं पेंडिंग रिजेक्ट कर दिया।
मैं ब्रिंग द इंजरी रिपोर्ट ऑन रिकॉर्ड।
ऑर्डर नहीं आया वजह कि स्टिल पेंडिंग।
क्या बोलेंगे इंजरी रिपोर्ट पेंडिंग है मतलब?
उसको अगर 2 वीक्स के बाद दिया तो
आप तो इन्वेस्टिगेशन स्टेज में आ जाते हैं, इंजरी रिपोर्ट पेंडिंग है तो क्या बोलेंगे? कैसे ये 2 वीक्स के बाद में क्या चीज बनेगा? तब तक चार्जशीट हो जाएगा। चार्जशीट नहीं होगा तो हम आपको बेल नहीं देंगे, बता दे रहे हैं हम आपको बहुत क्लियर।
4 वीक्स करके 4 वीक्स में हो जाएगा।
तो समझ में नहीं आता है क्या बोलेंगे। Counsel for the petitioner seeks adjournment. And he submits that the matter be posted after 4 weeks.
Meantime, may I bring the injury report
Post on 18th of September. आपको जो करना है करिए।
without a direction of the counter they won't file.
केस डायरी में नहीं देते क्या आपको?
केस डायरी तो लिखवा
बिना without the order of the court they don't file counter.
They are very reluctant to law. They just don't pay attention even after the order. Unless the order is taken, we keep on writing letters, only then they get.
In the meantime, the state is directed to seek instructions and file counter affidavit along with the injury report of the victim and submit the case diary to this court, up-to-date case diary to this court, to the learned court master of this court on 16th of September. And also serve notice upon the informant of the case. उनको भी notice कर दीजिए। इनका antecedent and the antecedent report of the petition.
Item 24, BA 7392 of 2026.
Section 96. The petitioner is not named in the FIR. He is in custody since 28/4/2026. The informant has alleged that his both sisters, aged 13 and 16, they were not found in his house. And after searching also, so he suspected that someone has kidnapped. That is the statement in the FIR.
They have been recovered.
Yes,
The daughters have, the children have
charge
been
sheet has
recovered.
been submitted on.
No, बिना recovery के भी तो charge sheet हो सकता है. We do not know. At times the girls are not recovered. They were found missing.
But in the new audit,
In the FIR, they were
as
found
on the
missing.
location on Instagram, this petitioner has been, the police has arrested this petitioner.
Petitioner along with the girls. लड़कियां पकड़ाई हैं कि नहीं पकड़ाई हैं? लड़कियां पकड़ाई होंगी तो उनका स्टेटमेंट रिकॉर्ड हुआ होगा, आपको नहीं पता?
Lordship, it may be possible. Because in the new order has come that on location of the petitioner on Instagram and the bearing mobile number, the CDR mobile number, the petitioner has been arrested. In this case.
The case was missing. What
Yes.
is it? What is the period of custody? Since when are you in custody?
More than 3 months, 28/4/2026, and charge sheet has been submitted on 23rd/6/2026. As stated in para 13, and custody is in para 16. No criminal antecedent, and he is a boy of 20 years old. And there is a delay of 2 days in lodging of the FI. The girls went missing, as per the FI, the informant has said that went missing on 19th, and he has registered the case
The
on
state is
21st.
directed to serve notice upon the informant of the case and file a counter affidavit on merit. The council, let the case diary along with its enclosures be called for from the concerned court if the statement of the victim has been recorded under section 183 BNSS, the same be also forwarded with the present stage of the case. We'll find out whether they have been recovered or not. The counter affidavit that should be submitted. Counter affidavit will be filed by 21st, post on 24th.
Item 25, BA 7395 of 2026.
Petitioner,
103. This was the husband.
where did she die?
The father of the deceased is informant from. He states that his son-in-law.
What is the date of marriage? Date of marriage.
बोलते हैं कि
Dhukku marriage.
FIR में दवा फोन करके बताया कि गिर गई थी, चोट लग गया था। नेक्स्ट डे हम लोग मीटिंग करी थी, इंजेक्शन में आए तो उन्होंने बताया कि एक दिन पहले उनको मारपीट की। केस 15 के बाद
आई विटनेस तो बोल रहा है कि आप लोग मारपीट किया है एंड देन शी डाइड.
अब बोल रहे कि एक दिन पहले वो आ रहे थे उसको
What is the date? What is the date of death? 12 तारीख को ना? अब 12 तारीख को मारपीट की.
हाँ 12 को
और उसी दिन मरी.
उसी दिन साहब ये खबर भेजे
She was also pregnant.
She was 9 months.
9 months. स्टमक इंजरी से तो नहीं मरी है वो.
नहीं वो इसमें
हेड इंजरी से मरी है.
हाँ इतनी डॉक्टर बोली तो आया मेडिकल ऑफिसर और पोस्टमार्टम वैसे the cause of death shock and damage due to head injury fractured by heart and brain. Page 15 second last one.
क्या कर सकते हैं बताइए. Heard the learned counsel appealing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is the husband of the deceased
Charge frame हुआ 10/4/2026
and charge has been framed on 10/4/2026 for the alleged offence under section 103 of BNS. He submits that the deceased died as she slipped and sustained injuries. The learned counsel for the state has opposed the prayer for bail and has submitted that as per the improved order itself, the deceased was pregnant and it has been recorded that people around saw the petitioner assaulting the daughter of the informant, due to which she fainted on 12/12/2025 and she died in her in-laws house on 7 p.m. on the same day. She has also submitted that the victim died due to acute shock and hemorrhage due to head injury impacted by hard and blunt substance. After hearing the learned counsel for the parties and considering the materials collected during investigation as recorded in the written order, and also the fact that the victim was collected during investigation. Against the petitioner, this court is not inclined to enlarge the petitioner on this. Evidence कितना हुआ?
अभी नहीं
अभी शुरू नहीं हुआ.
Article 26 BA 7400 of 2026.
In this case, I am waiting for the information.
Okay, where is the petitioner? Your file appointment.
No, Lordship, I have brought the file of
The council.
My submission. Now the parties have solemnized their marriage vows. They are living together as an husband. She is a widow mother having 3 children, and her husband had died during Corona period, and thereafter they are
Custody कब से है sir?
Charge sheet has been 9/6/26. As per my
9/6/26 को charge sheet होगा.
Please, he is in custody.
Charge sheet कब?
Thereafter his charge sheet has been submitted. This is my information.
Charge sheet has been submitted.
On the basis of a
You are
complaint.
for the informant. You have no objection for bail. Wakalat number 5. Wakalat number 5 by the on behalf of the informant during the court proceedings is taken on record.
And step 2 is the mother's photographs to show.
The counsel for the petitioner submits that the allegation against the petitioner is that the petitioner committed rape upon the victim on false pretext of marriage.
She is it about 31 years and widow also.
The victim is aged around 31 years and also a widow. The learned counsel for the counsel for the petitioner further submits that the petitioner and the victim have solemnized their marriage.
It's also apparent from the impugn order.
Which is also apparent from the impugn order. The learned counsel for the informant, who also is the victim of the case, has submitted that he has no objection if the petitioner is enlarged on bail. And he also submits that marriage has been solemnized between the petitioner and the victim. The counsel for the state submits that if marriage has been solemnized, he also has nothing to say. After hearing the learned counsel for the parties and considering the fact that charge sheet has already been submitted and the informant has no objection to the prayer for bail, the petitioner is directed to be enlarged on bail. As per Wakalat number 5, the report proceedings is taken on record.
Item 27 BA 7402 of 2026.
Yes, petitioner.
इसमें IR 103(1) रजिस्टर्ड हुआ, चार्जशीट सबमिट हुआ है
82 double dead.
पेज 20 रिटन रिपोर्ट.
आप कौन है? हस्बैंड. शादी कब हुआ?
7 साल पहले. पेज 20 रिटन.
Cause of death क्या है? And where did she die? FIR में बताइए. FIR में
है पेज 20 में. निवेदन पूर्वक कहना है कि मैं शिवानी देवी हूँ, 47 वर्ष, पति निवासी
झारखंड के रहने वाली हूँ। कल दिनांक 15/3/2026 को समय रात्रि 9 बजे लगभग मेरी पुत्री शकुंतला देवी के ससुराल ग्राम हुआ पोस्ट फतेहपुर थाना पूर्वी गुंडी जिला धनबाद से फोन आया कि मेरी पुत्री शकुंतला की तबीयत खराब हो गई है। तब हम लोग रात के 12 बजे के आसपास फतेहपुर पहुंचे तो देखा कि मेरी पुत्री शकुंतला देवी मृत अवस्था में पड़ी है। मेरी पुत्री के गाल व गले में चोट के निशान है। मुझे विश्वास है कि मेरी पुत्री शकुंतला देवी की हत्या मेरे दामाद उज्ज्वल विवाह 25 वर्ष के द्वारा कर दी गई। Only on the basis of suspicion कोई डाउरी डिमांड का कोई एलिगेशन नहीं है। क्रूरटी, फिजिकल हरासमेंट, मेंटल हरासमेंट कोई नहीं। Petitioner in custody since
He was under influence of alcohol.
confession में तो
Not on the basis of the confessions, but of this petitioners also and independent witnesses also stated that he was under influence of liquor.
An altercation had taken place with regard to dowry. He abused, assaulted.
Yes, not there was in
Closed her in the bathroom.
Confessional statement ये भी आया है कि however after some time his wife closed herself into bathroom and committed suicide.
That's right. She closed herself in the bathroom and then she committed suicide.
उनका स्टडी में 7/4/2026 पहले किसी तरह का कोई कंप्लेंट नहीं है डॉक्टर डिमांड का।
The counsel for the petition submits that there is no allegation or demand of dowry. And the charge sheet has been submitted under section 80 with bracket 2 of BNS. And charge has also been framed. Let the case diary along with its enclosure, including the postmortem report, be called for from the concerned court. Counsel for the state. The state is directed to serve notice upon the involvement of the case and file a counter affidavit on it. The counter affidavit will be filed by 21st, post on 24th.
Item 28, BS 7406 of 2026.
At the request of the counsel for the petitioner, close this case on next Wednesday. Next Wednesday, 50th. 19th. When is that? 19th.
Item 29, BA 7413 of 2026.
Also.
Yes, madam. Madam, there is right now ordinary delay of 3 days, madam, in lodging the FIR.
From where the girl has been recovered?
Madam,
दिल्ली से रिकवरी आपके साथ दिल्ली से क्या लेना है? She was pregnant also.
No.
देखिए ना, इंटरव्यू ऑर्डर में गलत लिखा है। Page number 17. In a statement recorded under section 183, her age is mentioned as 17 years. She stated that she went to Chotu Kumar to Delhi, married with him and physical relationship, and also got established, due to which she is now pregnant.
My lord, they have married my lord. I went next year to the photograph of marriage, my lord. And mother, my lord, FIR कर दी हो victim. And my lord, sexual relationship established between the
Victim कहाँ
parties.
है? Victim कहाँ है? Where is she?
My lord,
Marriage हो गया तो आपके घर में होना चाहिए.
yes, my lord.
आपके घर में है?
My lord, I will not take this.
किसके पास है victim? Parents के पास है, आपके पास है, कहाँ है? Marriage हो गया?
Yes, my lord. My lord, the sexual relationship established was also mutual and consensual, my lord. I have annexed the photographs of marriage in annexure to
Just
page
a
number.
moment. The learned counsel for the petitioner submits that the petitioner and the victim are now married.
Yes, page 99 I have annexed the photographs.
The petitioner is 21 years of age.
Yes, ma'am.
And the victim at the time of age of age was 17 years of age.
17.
Now she has become major.
17 years 2 months, my lord.
अब तो मेजर हो गई होगी ना? तभी ना शादी हुआ होगा कि बिना मेजर हुए शादी हो गई.
My lord, during date of occurrence, her age was 17 years 2 months, my lord.
अब तो हो गया होगा ना?
Yes, ma'am.
मेजर. Date of occurrence कब का है?
ये 9/3/2026, my lord. And FIR was lodged on my lord of 12/3/2026.
Just a moment. The state is directed to serve notice upon the informant of the case and also upon the victim. खोज काट के serve कर दीजिए. And file a counter affidavit on merits. Let the statement of the victim recorded under section 183 BNSS be called for from the concerned court, along with the case diary and its enclosures. ठीक है, आने दीजिए. Counter affidavit be filed by 21st, post on 24th. Charge frame हो गया क्या? नहीं.
Charge sheet is
Item 30, BA 7414 of 2026.
Yes.
Motion is G 64, 62, 74, 76. Variance and plan 81. Now charges also already been.
Victim is 18 years. Then 13 years.
It is alleged by the informant victim that was she has come to the house of him and for the marriage was studied. Thereafter on at the event date 26 2026. The present petitioner came and tried to molest. Thereafter, she raised Mandas, he ran away, and after 2 days, the present case has been lost. During the investigation, it has come at paragraph number 30. There is a contradiction in her statement, wherein she has stated that कि वाहिनी ने बताया संदान को कपड़ा धोने के क्रम में घटना घटित होने की बात है. There is no such offense. They are the negotiable. The present petitioner is saying that her wife's house is virgin. The child is already with him. And his custody since 29/4/2026.
The state is directed to serve notice upon the informant of the case. Let the case ID along with the medical examination report of the victims and a statement, if any, and a statement recorded under section 183 BNSS be called for from the concerned court, along with the stage of the case, indicating as to whether the victim has now been examined as a witness of the concerned. Now, contract. Pose this case on 1st of September. The count of will be filed by 27. If the victim has been examined, a deposition will be forwarded to this court.
Item 31, BS 7419 of 2026.
Kidnapping. Age of the victim married about 20 years age, and informant is the father of the victim. He alleged that she went away from her house, and she got her during investigation. It has come with that petitioner claim for the purpose of marriage. One statement by the High Court in diary. उसमें बोलती है
शादी हो गई
शादी नहीं हुई। वो बोलती है कि हमको इंस्टाग्राम पर 3 महीना पहले बातचीत होता था। हमको on the day of operation को बुलाया और बोला कि चलो नहीं चलोगे तो हम आप क्या कर लेंगे। इसके बाद
The boy was already married. Married boy अगर किसी को in the false pretext of marriage किसी को ले जाए तो क्या बोलेंगे? इसके अलावा apart from kidnapping क्या है? He established any relationship with her?
कहा जाता है कि 183 का स्टेटमेंट भी हुआ है कि वो कहा जाता है कि बॉम्बे ले गए।
Married boy है और children भी है. Children भी है. नहीं, it was confined to kidnapping only or she was raped also?
कहा जाता है कि बॉम्बे ले गए, बॉम्बे में 2 दिन रहे और उनके साथ फिजिकल रिलेशनशिप हुआ। इनसे रिफ्यूज फॉर मेडिकल टेस्ट।
मेडिकल टेस्ट का तो कोई बात ही नहीं है, बॉम्बे लेके गए।
इन दोनों में लव क्या था? बातचीत होता था दोनों में।
In the pretext of marriage in a love affair था।
का स्टेटमेंट
कहाँ है अभी लड़की?
लड़की अपने
The state is directed to serve notice upon the victim as well as the informant of the case. Let the statement of the victim recorded under section 183 BNSS be called for from the concerned court, along with the case diary and its enclosures, and also the present stage of the case. क्या है present stage? The contract will be filed by 21st, post on 24th.
Item 32, BS 7420 of 2026.
The offense is 64, 323, 321, and 3 by 4 of the dowry provision. According to a third, the petitioner has committed rape upon the victim age of 25 years old. Earlier complaint was filed.
FIR 3(4) of Dowry Prohibition Act.
What we are going to the other relatives of the petitioner had gone in the house of complainant. हम इसको विदा करा के ले जाएंगे, accordingly विदा करा कर ले गए और घर में रखे 3 दिन तक। लेकिन लड़का के माँ पिताजी बोले कि हम शादी तभी करेंगे जब 5 साल 3 दिन रही।
And you are the so-called husband. So-called husband. लड़की को विदा करा के 3 दिन रखने के बाद उसके बाद बोलेंगे कि अब शादी नहीं करेंगे, बहुत सीरियस बात नहीं है? हाँ?
उसके बाद डिमांड ऑफ दौरी
नहीं जाना था ना?
घर ही नहीं लेंगे, दूसरे जगह लेंगे। भैया को मेंशन
Or the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that petitioner is in custody since 21/4/26. 21/4/26. And the FIR was registered under section 64, 323, 341, 316 within bracket 1, 69, 319 within bracket 2 of BNS and section 3/4 of Dowry Prohibition Act. But charge sheet has been submitted under section 69, 64 within bracket 1, 64 within bracket 2 within bracket M, 351 within bracket 3 of BNS. The learned counsel submits that the petitioner has been falsely implicated in this case, and as per the allegation, the petitioner and his family members had taken the girl to their house, kept her for 3 days, and the petitioner had physical relationship with her, and ultimately they refused to marry, and a demand of rupees 5 lakhs was also made. You're for the informant, you're for the state. The learned counsel for the state has submitted that the petitioner and his family member came and told her parents of the victim not to institute any case, and they were taking the daughter after we died and will marry her to the accused. But ultimately, after 3 days, they refused to marry. And during these 3 days, the petitioner established physical relationship with the victim. After hearing the learned counsel for the parties and considering the seriousness of allegation and the fact that the victim was taken by the petitioner and his family members and was kept for 3 days, and subsequently the petitioner refused to marry. This court is not inclined to enlarge the petitioner on bail. It is rejected.
Item 33, PS 7424 of 2026.
The petitioner is in custody since 9th May 2026 for the offense alleged in section 64 to be related to 51 2 of the BNS LLC.
What is the stage?
Stage chassis and subject.
Under which section? And what is the allegation against it?
Allegation is case number 14 is there. In fact, I would like to invite Yusuf's attention to certain fact that the victim happens to be the bhabhi of this informant university, and there is a long-term dispute with respect to land. I am placing case number 14 university with respect to certain land. सबने निवेदन है कि जो कहना है कि मैं सचिन सच जिला निवासी हूँ, दिनांक 29 से 26 की रात 11 बजे मेरे किराए के मकान में मुकुंद मणि पिटिशनर सचल डेरा घर पर आए और जान से मारने की धमकी देने लगे और मेरे साथ जबरन शारीरिक संबंध बना लिया। मैं डरी जमी रही, जान से मारने के डर से किसी को नहीं बताई। इससे पूर्व मेरे डेरा पर उक्त व्यक्ति आकर मेरा बेटा की जान मारने की धमकी दिया था और मेरे साथ शारीरिक संबंध बनाया। मैं अपने बेटा को बचाने हेतु किसी को नहीं था। अंत में लाचार होकर इस संबंध में थाना में आवेदन दे रही हूँ ताकि मैं अपने और अपने बेटा का जीवन बचा सकूं। यही कहना चाहती हूँ। Allegation is this that but in fact this is a false story. Why I am saying so that the petitioner happens to reside at Hazaribagh, and this incident is at Tandwa, that is nearly 1.5 nearly 100 kilometers away. and there is a dispute with respect to land, and the incident is said to be of 29th January 2026, and the FIR has been registered on 31st University, that is related at least 2 days University. And in addition to that, Lordship, I would like to submit to Lordship that I have given specific statement that this petitioner, who happens to be the Bhutia of the informant, is in a long-run battle with respect to Bell Bazaar at Tandwa. और अपनी भाभी है जो 2 बच्चे की माँ है. I must not say that she is aged about 30 to 31 years, and even then she has alleged that just in order to exert pressure so that I cannot get the share in that land, this Rawls and Federal case is not supported by medical and nor the.
Before the learned court, you had stated that there was love affair between.
Yes, that was in fact, I must say that was actually incorrect statement given by the.
वहाँ पे love affair का कहानी, यहाँ पे land dispute का कहानी.
नहीं, वो कुछ तो था ही नहीं, उस इसके लिए हम नहीं बोलेंगे क्योंकि ये सी हैज इवन मेड कंप्लेंट टू दी बार कि ऐसा कुछ हम बोले थे नहीं, वकील साहब को वो कर दिए हैं, ऐसा कोई बात ही नहीं, वकील साहब को बोले थे ये अपने से देते हैं, ये नहीं है, क्योंकि कहीं भी नहीं है पूरे स्टोरी में.
सोच लीजिए अभी आपके ऊपर भी कुछ ना करे.
आप कह सकती है, लेकिन जो हम जो कह रहे हैं इससे बोल रहे हैं. और एक चीज और बोले, मुझे ड्यूरिंग प्रेगनेंसी हम सीडीआर भी लाए हमको, ये दिखा रहा है कि ये टंडवा में, ये हजारीबाग में जो बीच में निकालेगा, उसमें देखेंगे
सीडीआर उसमें आया होगा.
हाँ,
इन्वेस्टिगेशन में
आया जो कि 150.
The learned counsel for the petition submits that at the time of occurrence,
yes,
the petitioner was in
Hazaribagh
and not, which is around 150 kilometers away.
150 नहीं, जो टंडवा is 1.5 hours लगता है, तो वो 1.5 hour distance हजारीबाग.
1.5 hours तो distance नहीं होता है.
टाइम लगता है.
Okay. He was in Hazaribagh and the place of occurrence is Tandwa, which is far away from Hazaribagh.
Yes.
He submits that this has come during investigation based on the CDR location.
Yes.
Charge sheet has been submitted.
Yes.
And petition has been falsely implicated on account of land dispute.
Yes.
The state is directed to serve notice upon the informant and file a counter affidavit. Let the case diary along with his enclosures be called for from the concerned court, and also the statement of the victim recorded under section 183 BNSS with the stage of the case. And the counter affidavit will be filed by 21st post on 24. Sub with all enclosures.
Yes.
Item 24, PA 7427 of 2026.
Offense under section 1083 of the BNS. Lordship, I am the husband, and it is alleged that in the year 2017 marriage was held, and thereafter, Lordship, I was working in out of the station, and she has committed suicide. At the time of incident, my mother and father were present in the house. Death has been opined because of asphyxia due to hanging. My mother, she has been enlarged on anticipatory bail by Honorable High Court Justice. This is the order. And charge sheet have been submitted under section 108 of the BNS.
There is a demand of dowry.
Lordship, initially it has been stated, but Lordship, can you see the page number 16, Lordship, very relevant. Page number 16, the bottom. मेरा दावा है कि देव नारायण प्रसाद हरिजन एवं परिया देवी ने मेरी बहन का हत्या कर दिया है और फांसी लगाने का झूठा कहानी बना दिया. Lordship, परिया देवी, she is my mother, Lordship, she have been allowed on anticipatory bail. I was not present in house, Lordship. I am working in some other state for the livelihood. At the time of incident, I was not present. And there was no external or internal injuries.
चार्जशीट मदर-in-law के अगेंस्ट में हुआ ही नहीं है।
अभी इन्वेस्टिगेशन उनके पास पेंडिंग था।
और
Only
अभी
2%.
क्या स्टेज?
Your
अभी भी
Lordship-
इन्वेस्टिगेशन उनके खिलाफ पेंडिंग?
No, Your Lordship, till today, and Your Lordship, father-in-law and husband both were sent to jail.
उन्होंने अपना बेल बॉन्ड नहीं भरा है मदर-in-law ने?
Your Lordship, just 2 days back, Your Lordship, her bail has been executed. On 30th of July, Your Lordship.
आप तो बोल रहे हैं माँ घर पे थी, पिताजी घर पे
Your
थे, सारा एलिगेशन ऑफ असॉल्ट उनके ऊपर है। अभी आप माँ का दिखा रहे हैं एंटीसिपेटरी।
Your Lordship, she have been granted.
By stating that charge sheet has been submitted against the father-in-law and the husband.
Yes. Because these 2 persons are in custody. In page number 16, the very next page. My name has not been whispered here. Initially only.
You are not being made an accused in the FIR.
FIR I have been made. Initially.
इसमें नहीं whisper किया।
Lordship, page number 16 में read Lordship. सितंबर 25 में मेरी बहन को देवनारायण प्रसाद हरिजन ने दहेज मार्केट के घर से भगा दिया था। तब मेरी बहन ने जिलवा बड़ी को आवेदन दिया। थाना वाला बोला कि बहन का भैंसुर और सास को थाना बुलवाया, डांट डपट सुलभ समझौता कराया। इसके बाद भी मेरी बहन को उपरोक्त व्यक्ति रोज मारपीट गाली गलौज करते थे। दहेज के लिए 1 लाख रुपए लाने के जवाब देते। दिनांक 21/1/26 को शाम 7 बजे मेरी बहन ने मुझसे बात की थी। मुझसे बोली कि सरस्वती पूजा के बाद आने के लिए बोली थी। दिनांक 23/1/26 को मेरी बहन के ससुराल के पड़ोसी ने मुझे फोन पर बताया कि आपकी बहन ने फांसी लगाई। तब से अन्य रिश्तेदारों के साथ सहाकर अपनी बहन के ससुराल गया, देखा मेरी बहन के गला में चारों तरफ नीला दाग था। मेरा दावा है कि देवनारायण प्रसाद हरिजन परिया देवी ने मेरी बहन की हत्या कर दी है, फांसी लगाने को कहा।
And Devnarayan Prasad is the
my father.
Father-in-law.
Father.
क्या बोलना? इनके ऊपर डायरेक्ट एलिगेशन कहाँ? He was not there. इसमें FIR से तो नहीं पता चलता है that you were not there at the place of offense.
I am working in so many. That's why they have not inserted my name. अगर हम
केस डायरी में आया होगा ना?
केस डायरी में आया होगा।
क्या पे और काम कर रहे हैं? कहाँ काम करते हैं?
कंपटीशन में लिखे भी हैं।
कहाँ काम करते हैं?
कहीं चेन्नई में काम। अब स्टेटमेंट भी दिया आपने बेल पिटीशन के तरफ से।
At the time of occurrence आपका CDR रिपोर्ट आया है? The state is directed to serve notice upon the informant of the case and file a counter affidavit on merits. The learned counsel for the petitioner submits that primarily the allegation is against the father-in-law and mother-in-law who were staying with the deceased, who happens to be his wife, and the petitioner has been working in Chennai. He submits that it must have come during the investigation. Let the case diary along with the its enclosures be called for from the concerned court. And the state of charge कब हुआ? Counter affidavit will be filed by 21st, post on 24th.
Item 36, VA 7436 of 2026.
मारपीट एवं घोटिया आरोप है राजेंद्र विश्वकर्मा इज द पिटिशनर आरोप है कि इन्होंने सर पर टांगी से मारा बट नो इंजरी ऑफ एक्स इज फाउंड और एनी इंजोर्ड टांगी से किसी पर नहीं है एक पर है रामजी विश्वकर्मा जिसका हाथ फ्रैक्चर किया वो संजय विश्वकर्मा पर आ एक बार हम पढ़ देते हैं फाइल
आपके ऊपर क्या एलिगेशन?
मेरे ऊपर है कि हम टांगी से मारे लेकिन टांगी का कहीं कोई इंजरी
टांगी से किसको मारे?
हम मारे हैं रामजी विश्वकर्मा
रामजी विश्वकर्मा का। रामजी विश्वकर्मा का
टांगी का कोई इंजरी
दिखाइए कहाँ कहाँ से बोल रहे हैं कि रामजी विश्वकर्मा को टांगी से
आया है
बताइए
ऑर्डर शीट में कि ये टांगी से उनको मारे हैं हाथ फ्रैक्चर हो गया है thereafter the injured Ramdeep Viskarma was referred to the NSMH but due to fracture found on his
हेड नहीं हो तो हैंड होगा वही गलत टाइपिंग गलत हो गया है हैंड है हेड का कोई इंजरी
Well, under counsel for the petitioner submits that it has been alleged in the FIR that the petitioner had assaulted Ramji Vishwakarma. The petitioner
राजेंद्र विश्वकर्मा
Rajendra Vishwakarma had assaulted.
हैंड में है
Just a moment. Had assaulted Ramji
राजेंद्र
Vishwakarma.
विश्वकर्मा अपने हाथ में लिए टांगी से सर पर वार
Right.
अब सर में
Had assaulted.
हेड में कोई इंजरी
अरे
नहीं
भाई इतना बोलते हैं क्या बात है?
मेरे पास इंजरी है
आपके पास सब कुछ है क्योंकि आप खुद डायरी लिख रहे हैं इसलिए आपके पास सब कुछ है आप ही लिख रहे हैं क्या डायरी चार्जशीट हो गया आपका
जी
had assaulted Ramji Vishwakarma on his head but as per the injury report the fracture was found on his hand. He submits that it has been wrongly recorded in the appeal order that there was fracture on his head. And there has been no head injury upon Ramji Vishwakarma. Let the case diary along with the injury report be called for from the concerned court. Counsel for the state is also directed to file counter. By 21st, counter by 21st, post on 20.
For admission item 28, ABA 2980 of 2026.
Yes, petition. Yes. Where is the respondent? Respondent is not available today. You have got your statement recorded.
My attendance was marked on 2nd July. My attendance was marked,
And
then further date was not given.
any supplementary affidavit filed? Supplementary affidavit has been filed.
No, my
As to what happened thereafter, what material has been collected.
the state has not filed anything.
ACB has to file.
ACB has to file. Because
You have filed any supplementary
no,
affidavit?
I have just thinking what has happened in this case, minors. It's a case of DA, disproportionate assets.
That's right. You were supposed to give your details, etc. So
Yes,
you have done the needful.
I have done. I was doing the needful by post. So minors had asked me to appear before the police.
So you appeared.
I appeared. They marked my attendance, but no further progress was undertaken. As per my instruction.
So your your instructions which is not on record, how do I take?
The state has to find the
State has to
yes,
find.
ma'am.
That's
That's my
right.
this is my request, ma'am.
ABA number 2980 of 2026. The learned counsel for the petitioner is present. Nobody appears on behalf of the state of the ACB. The counsel for the petitioner submits that in terms of order dated 25/6/2026, he had appeared before the concerned authority on 2nd of July at 11:30 a.m. The counsel for the ACB is directed to seek instructions and file a supplementary counter affidavit in this case, indicating as to whether the petitioner has cooperated with the investigation and what other materials has been collected against the petitioner. Pose this case on 27th of August. The supplementary counter affidavit be filed by 24th. With a copy of this order be forwarded to MS Nehala Shindini, who appears on behalf of OC.
The interim order will be
Soft copy now. The interim order passed earlier is continued till 27.
Item 39, BA 0698 of 2026.
Yes, petitioner.
Number 28/7/2026. Honorable Court will direct the state to file counter affidavit.
Yes, I counter.
That the video or photograph has been recovered or not.
Has been recovered.
As per the counter affidavit, it is not clear that it has been recovered or not. Only the paragraph has been referred. So the state can better say whether it has been recovered or not. Since mobile has not been found from the petitioner.
The girl belongs to Andhra Pradesh. The girl belongs to Andhra Pradesh.
No, from the Ranchi. From the Ranchi and see.
मैं आंध्र प्रदेश में रहती थी. She was staying in Andhra Pradesh and she got in touch with the petitioner.
लेकिन घटना के दिन क्या हुआ कि बुलाएं अपने एसोसिएट्स के साथ इनको ब्रूटली मारे और मार करके कहीं छोड़ दिया गया. पुलिस कॉल किया इसके पिटिशनर के घर में, तो इसकी मां जो है सो एफआईआर की इन्फॉर्मेंट के ऊपर और अदर लोगों जो सहयोगी थे उनके ऊपर हुई.
You see, the allegation is that you had disclosed your name as Raja Babu.
हाँ.
And she came to know that you are from a different religion.
Due to that reason,
reason, the case has been instituted, right?
Friendship on Facebook, 2 years of the relationship, and thereafter fight, money transaction,
Inter-religion बहुत मुश्किल है.
Allegation of the viral of the video or photograph.
Charge sheet has been filed under
Yes,
which section?
charge sheet has been filed.
Under which section?
Charge sheet has been filed under section 351, 352, 69 of the 79 of the BLS and 67A, 66E IT Act.
IT Act में आया इसका मतलब ही वही.
हाँ मतलब वही है.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case and he is in custody since. Custody बताइए.
15/4/2026.
Since 15/4/2026.
Cases
And
charge
charge sheet has been submitted.
Charge has been framed on 21/7/2026.
Charge has been framed on 21/7/2026
2026.
for the alleged offence under section.
Under same section only.
Registered over the same section.
The registration हुआ है मुझे.
Same section.
ये जो
registration हुआ था 67A में.
Yes.
और चार्जशीट हुआ है जो
67A and
66
66E. दोनों same है लोग।
हाँ same section में हुआ है।
And charge sheet has been submitted under section 351 within bracket 3, 352, 69, 79 of BNS and section 67A, 66E of the IT Act.
Case is fixed for evidence on
The
13th August.
Case is fixed
For
fixed
evidence.
for evidence. The learned counsel for the state has opposed the prayer for bail and has submitted that
The alleged video is produced by the victims and several witnesses stated that they have seen them.
the alleged video was produced by the victim and several witnesses have stated that they had seen the obscene video.
And alleged sim is in name of.
Sorry?
Alleged sim is in name of this person.
And the alleged sim is in the name of the petitioner. The statement of the victim has also been received from the concerned court, recorded under section 183 BNSS. After hearing the learned counsel for the parties and considering the fact that the victim has supported the allegation against the petitioner, who had disclosed his different name and when she and subsequently she came to know that the petitioner belongs to a different religion. She has also stated that the petitioner assaulted her and also demanded money and made her video viral. After hearing, considering the nature of allegation and the fact that victim is yet to be examined in the trial, this court is not inclined to enlarge the petition and bail is rejected.
Item 40, DS 6737 of 2026.
This petition.
Offense under section 96 and 56, one of the BNSS. Last time.
Statement I victim is 15 years. 14 years.
14 to 15 years.
ये तो बोल रही है कि लड़का के साथ रहना चाहती है, खुद ही उसके घर चली गई थी, इसके पेरेंट्स इसकी जबरदस्ती कहीं और शादी करा। चार्जशीट हो गई, चार्जशीट 183 का स्टेटमेंट उनको दो। छोड़
आप मेडिकल एविडेंस में कुछ नहीं है।
नहीं, वो खुद ही गई है ऐसा बोल रही।
हाँ,
अब देखिए
अपना
इनका
मर्जी से।
or the learned counsels appearing on behalf of the parties.
Medical evidence में no sign.
Counsel for the petitioner submits that the petitioner is in custody since
9/11/25.
9/11/2025 and he has been falsely implicated in this case. ठीक है ना? The learned counsel has submitted that though the victim was 14 years of age, but she had voluntarily come to the house of the petitioner.
She was,
And she also refused medical examination.
medically she was examined.
She was examined.
Later on, examined and no sign has been.
She was examined.
Okay.
Later.
The victim was medically examined, but no sign of any sexual assault was found.
Definite sign of rape is not there. Also. That is
No definite sign of rape or sexual assault was found as per the medical report.
she was recovered along with the petitioner from the.
The learned counsel for the state has submitted that the victim was recovered along with the petitioner from the house of the petitioner.
Patna
No,
railway
Patna
station.
railway station.
From Patna railway station.
He has taken her to Mumbai,
Delhi.
Delhi.
Then he has
From
gone
Patna
back.
railway station, and the petitioner had taken the victim to Mumbai and
Delhi.
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 He might counter to Delhi and stated in Parliament.
इधर ये the learned counsel for the state has referred to the counter affidavit to submit that the victim was recovered from the railway station at Patna. ये ना पेज छूट गया था. I did not see certain pages. The statement of the victim recorded under section 183 has been placed on record, which reveals that the petitioner has declared her age as 13 years, and she has supported the allegation made against the petitioner. क्या नाम है victim का?
Victim is Karina Kumar.
ये प्रकाश शाह कौन है?
Prakash is the father of.
Father of the victim.
He is the father of the. इसमें भी victim लिख दिया है. वही तो दो जगह victim लिखा हुआ है.
Father of the victim is the examined. Mother of the victim is the examined, and the brother of the victim.
Yeah, also, the victim is only 14 to 15 years.
Sorry?
Victim is only 14 to 15 years.
Yes.
And we had stated that मेरे पास बहुत सारा घर है तुमको लेके चलेंगे. And see when.
नहीं ये दो अलग-अलग स्टेटमेंट है कैसे है इसमें?
180 statement.
नहीं एक 183 statement of victim recorded under section 183 BNSS. ये दुमका PS केस नंबर 198 of 25.
Yes sir.
एक है राजमहल PS केस नंबर 167 of 26.
That is not.
That is not the. इसमें देखिए राजमहल PS केस नंबर लगा हुआ.
That is not.
That is not the case ना?
Yes, sir.
इसमें दो लगा हुआ है victim का statement. लगता है किसी और का यहाँ लगा दिया. इसमें किसी और का BA नंबर कितना है ये? 6737 ये दूसरे केस का इसमें लगा दिया. इसीलिए कंफ्यूजन हो गया. दूसरे केस का है. ठीक है. The statement of the victim recorded, the victim has supported the allegation made against the petitioner recorded under section 183 BLSS. In view of the fact that the victim has supported the allegation and has also stated that the petitioner had taken the victim to Delhi. This court is not inclined to enlarge the petitioner and bail, hence rejected.
That is the 269. Victim to मिल गया. Medical report has been proved that is not.
At this, the counsel for the petitioner has submitted that a few witnesses have been examined during trial.
Yes.
The state is directed to ensure that the remaining witnesses are promptly produced before the court, so that the trial is taken to a logical end. The counsel for the state is directed to communicate this order to the SP of the concerned district and to the director of prosecution to ensure compliance. इसका दूसरा वाला केस का स्टेटमेंट निकाल के अलग करिए. दो स्टेटमेंट ऑफ विक्टिम. I am absolutely confused because of that.
Seen it in the case that she has supported the case in
Yes.
under 180.
वो दूसरा केस का इसमें लगा दी.
That's why the confusion.
Yes.
Item 41.
उस केस में तो बिल्कुल ही सब मतलब she has said that I had gone myself और क्या क्या बोला.
But she is only 14 years old.
Yes,
If
yes.
she had gone.
That's right,
That's
that's right.
the cases.
Item 41, VA 6745 of 2026.
The last page of my absence, we should call the postmortem report.
That is routine order we call for this. What is the allegation against it?
Allegation is that the deceased was missing for 3 to 4 days. After that, the family members of the deceased found that the dead body was found in a well.
Victim was missing for 3 days.
Yes. We have reported it to the police and also informed the family members also. The husband himself informed.
Where is the well situated?
It is about 400 to 500 meters away from the house.
Case of co-accused has been considered, I suppose.
No.
Not yet. Since when are you in custody? You are the husband.
We are the in-laws and brother-in-law, father-in-law, and mother-in-law.
Brother-in-law, father-in-law, and mother. Husband is in custody.
Yes. Yes.
Husband
Yes.
is in custody.
Yes.
Your father informed. Please go on.
The mother-in-law was absconding. She was, and thereafter she surrendered on 4/5/26 after 2 months.
What is the allegation? Let us have a look at the FIR. Read the FIR, please.
Yes. सविनय निवेदन है कि मैं अनिता देवी उम्र सच मेरी पुत्री प्रीति देवी की शादी विगत 10 वर्ष पहले सुबोध रवानी पिता दिलीप रवानी ग्राम सच जिला जामताड़ा के साथ हिंदू रीति रिवाज के साथ किया गया था. दिनांक 5/3/2026 को मेरे दामाद सुबोध रवानी से मोबाइल द्वारा पता चला कि मेरी पुत्री प्रीति देवी लापता है. उसके बाद हम लोग पूरे परिवार के साथ रिलेटिव पहुंचने पर पति सुबोध रवानी ने बताया कि घर से कहीं चली गई है. हम लोग खोजबीन लगभग 4 दिन करने के बाद आज दिनांक 9/3/2026 को ग्रामीणों द्वारा सूचना मिली कि ग्राम तिलगाड़ी के
What is the cause of death?
and asphyxia due to drowning. That is, and most importantly, the informant in her cross examination she has stated that मैं पढ़ना लिखना नहीं जानती हूँ, मैं नहीं कह सकती हूँ कि थाना में संबंधित आवेदन में क्या लिखा.
So she has turned hostile. She has been declared hostile.
But in her cross examination it has come. I have the certificate, photocopy of the certificate.
Yes, madam, what do you have to say? See, they informed her, what is there? 10 साल पहले शादी हुई है.
10 साल पहले शादी, they are having 2 kids. But the deceased was always burdened with the works and in her restatement, the informant in her restatement has stated, I'll read that. दामाद सुबोध रवानी बाहर में काम करने जाता था और महीना में 1-2 महीना बाद काम करके घर आता था. मेरी बेटी घर पर रहती थी. उसका देवर छोटू रवानी का शादी नहीं हुआ है तो घर का काम सारा बोझ मेरी बेटी तो ही घर का पूरा काम करना पड़ता था। घर का काम कभी कभी ठीक से नहीं कर पाती थी, तब घर वाले उसके सास ससुर देवर मिलकर इसी बात को लेकर काफी लड़ाई झगड़ा करते थे और पूरा परिवार के लोग मिलकर प्रताड़ित करते थे। घर का सारा काम करवाते थे, साथ में 2 बच्चों का भी देखभाल करना पड़ता था। ये बात मेरी बेटी मोबाइल से पहले भी बात करके बताती थी, लेकिन
For the learned counsel appearing on behalf of the parties, the counsel for the petitioner submits that the petitioners are the in-laws of the deceased, and the deceased was found missing from home, which was duly informed to her parents.
Only mother, father is.
this one
Just a moment. To her parents, to her family members, and ultimately after 4 days, her body was recovered from a well. The learned counsel submits that as per the postmortem report, she died due to drowning. The marriage was performed 10 years prior to the date of occurrence. The petitioner is in custody since
10th of March
the
2026.
petitioners are in custody since
10/3/2026.
10/3/2026.
petition number 3 is in custody since 4/5/26.
Charge sheet सबको हो गया?
Yes. All
Uh, okay. The learned counsel for the informant has, while opposing the prayer for bail, has submitted that the petitioners has been avoiding arrest for quite some time.
Only
The mother-in-law.
mother-in-law.
The mother-in-law has been avoiding arrest for quite some
2
time,
months.
She's
for around 2 months, and petitioner number 2,
1 and
1 and 2, they were arrested on 10.
the petitioner number 1 and 2 were arrested on 10/3/26, and petitioner number 3 is in custody since
4/5/26.
4/5/26. She has referred to the restatement of the informant of the case and has submitted that the deceased was overburdened with household work, and she had to take care of 2 children also.
2 children are
And
unmarried brother-in-law.
just a moment. The deceased was overburdened with household work, and she was to take care of 2 children. And on account of these household works, she was abused by the petitioners. The husband used to go out for work. After hearing the learned counsel for the parties and considering the fact that charge sheet has already been submitted,
Charge sheet has been submitted under section 108
has been submitted under section 108
and 35.
and 34
35.
and 35 of BNS, and the marriage had happened 10 years prior to the date of offence. The petitioners are directed to be enlarged on this. पास ओवर पे हम लोग सवाल कुछ करेंगे या फिर मीटिंग करते हैं.
Item 42, BS 6748 of 2026.
Yes, madam.
Was as per the last order 182 statement.
Yes, what do you have to say? Charge sheet open. What is the age of the petition?
20 years.
ये बोल रही है बहुत बड़ी उम्र के लड़के से शादी कर रहे थे घर वाले, इसीलिए हम भाग के चले गए और पिटिशनर से शादी कर ली. ऐसा ही स्टेटमेंट है इसका वाणी में. Heard the learned counsels appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case and is aged only 20 years. She submits that the statement of the victim recorded under section 183 has been drawn from the concerned court. That may be perused, and the petitioner is in custody since 7/5/26. Charge sheet has been submitted. The learned counsel for the state has opposed the prayer for bail. After hearing the learned counsel for the parties and upon going through the statement recorded under section 183 BNSS, it appears that the victim, though aged 15 years, has stated that her family members were getting her married to a person of advanced age, and therefore she ran away from the house herself and went to the house of the petitioner. In view of the, and then she got married with the petitioner on her own. In view of the fact that charge sheet has already been submitted and the victim had herself left her house and went to the house of the petitioner is admitted to be enlarged on. कितना है पास?
3%.
कितना? Second half में कट केस.
Diary or postmortem report will be 103 letters.
कौन सा केस?
And the password matter, that is item number 9.
चार्ज शीट हो गया है. चार्ज शीट हो चुका है.
Charge
आइटम
sheet
नंबर
हो गया.
9 हो चुका है ना सर चार्ज शीट?
I'm sure, लेकिन तो 2.5 महीने से कस्टडी में डायरी पोस्टमार्टम रिपोर्ट मंगा लिया जाए अपनी.
The learned counsel for the state is directed to file a counter affidavit in this case and produce the up-to-date case diary before this court and submit the same to the learned courtmaster by 27th.
पोस्टमार्टम रिपोर्ट.
Case diary along with its enclosures, particularly postmortem report. Post this case on 1st of September. और बाकी दो मैटर और हैं. Yes, what is the state of the case? कहाँ है लिखा है? कॉल करें.
Item 3.
It's under POCSO.
Yes.
POCSO.
Yes, yes.
Age.
The age is 5 years of this small girl.
She has made direct allegation.
Your Lordship, only one thing. She was being taken away by the present petitioner, aged about 60 and more. And only on this allegation, Your Lordship, the case was filed. But subsequent on the next day, Your Lordship, it is stated that some statement was made by her. A small girl of 5 years of age, Your Lordship.
She has got her statement recorded under section 183.
That is the whole difficulty. Only to that extent, Your Lordship.
5 साल की लड़की है. मुश्किल.
And
the learned
Your
counsel.
Lordship will please see that it can be a case that he himself is out of mind. The allegation that has been leveled, Your Lordship, that cannot.
60 years कोई ऐसा उम्र नहीं होता सर.
No, but there is nothing of any act which will go to show that what was he trying to do. Your Lordship will please consider, and he is already in jail custody. That is why I was only praying, Your Lordship.
Sir, he is in the neighborhood.
Yes.
इसीलिए अभी निकालना मुश्किल.
He will leave the village. Your Lordship, that undertaking may be given.
No. ऐसा किसी को घर से नहीं निकाल सकता. Heard the learned counsel appearing on behalf of the parties, the learned counsel for the petitioner submits that the petitioner is aged 60 years and the victim is aged 5 years, and the case appears to have been lodged on account of some confusion. He has further submitted that the petitioner is in custody since 31/1/2026. The learned counsel for the state has opposed a prayer for bail and has submitted that there is an allegation of sexual assault by the petitioner on the victim, and merely because the petitioner is 60 years of age, the same has no relevance. The victim, in her statement recorded under section 183, as mentioned in the impugn order, has stated that the petitioner had tried to make such attempt earlier also, and the petitioner happens to be the neighbor of the victim. After hearing the learned counsel for the parties and considering the nature of allegation and the victim aged 5 years who has supported her statement recorded under section 183 premises, this court is not inclined to allow the petition on bail and is rejected.
Your Lordship, charges have already been framed, but not a single witness has been.
Charge of framework. At this, the counsel for the petition submits that the charge has already been framed. The trial has commenced, but not even a single witness has been examined so far. The state is directed to ensure that the witnesses are promptly produced before the court. The counsel for the state is directed to communicate this order to the SP of the concerned district and to the director of prosecution. आपका next date है तो बता दीजिए.
Next date you will also be given.
Next date रहता है तो हम लिख देते हैं such that they are clear. Anyways, there is one more case to be done.
Item 16.
16 is your case.
After a week, I see.
Investigation चल रहा. 82, right? Investigation चल रहा, आपको क्या हम रिलीव दे सकते हैं इस स्टेज बताइए.
After a week, Monday पर दिया.
You are the husband.
Let's see, I'm ready.
At the request of the counsel for the petitioner, post this case.